Okay, good morning, everyone. Welcome to the 7th in a series of webinars put on by the Jamaica Developers Association. I'm Dayton Wood, and for my sins and everlasting pleasure and honor, I'm the chairman of the Jamaica Developers Association. An association goes back 50 plus years, so I'm really happy to be in this hot seat and welcome you all this morning. None of this could, of course, be possible without the help of our sponsors, and also, or more importantly, without the guidance from above. So I ask you to join me in a short prayer. Omnipotent, omniscient, omnipresent God, unto whom all hearts be open, all desires known, from whom no secrets are hid. Cleanse the thoughts of our hearts by the inspiration of your Holy Spirit, that we may perfectly love thee and worthily magnify thy holy name. Amen. This morning, the focus of this webinar today is contracts, and more contracts. And then our quantity survey will let us know how you quantify these contracts. Or to lead us off and to get right and to moderate, our moderator today is no other than my mentor and big brother, Mr. Afif Assad Lazarus, distinguished attorney at law. Mr. Lazarus started off in life as in Mandeville, the center of the island, and expanded from there. He became one of the founders and lead singer and guitarist for the Tomorrow's Children. So you can see from a young age he was thinking in the future about tomorrow's children. He became an attorney after that and a senior partner at Livingston Alexander, leaving his outside of his legal profession, which is quite distinguished. He has had a lot of private experience in the private sector and the public sector, being chairman of the various boards, Jamaica Development Bank, Agricultural Credit Bank, Betting, Gaming and Lotteries Commission, and so on. And in his private avocation, he has had leadership roles at Guardian Life and other major companies in Jamaica. So without further ado, we'd like to invite my big brother, Mr. Afif Assad Lazarus, to take over as your moderator. Afif?
Thank you very much, little brother Dayton, for your very kind words. Good morning, everybody. As you heard, my name is Afif Lazarus, and I'm your moderator for this most important webinar today on the subject of exploring contracts, joint ventures, and the quantity surveyor's role in real estate development. We are blessed with the presence of a distinguished panel of the most experienced and knowledgeable professionals in the industry. And I trust that this webinar will be as enjoyable as it will be informative. So I invite you now to sit back, enjoy the presentations, and we look forward to your participation in the Q&A sessions on the various topics. Now, on that note, I would just say that if you have any questions or comments in the Q&A sessions, you can use one of two methods of communicating with us. You can either raise your hand, and our technical team will get you to be asking your questions on screen, or you can use the Q&A icon, not the comments icon. You must use the Q&A icon to write your question or whatever it is, and we will be referring to that and putting the questions to the panelists. So without further ado, it is now my first pleasurable duty to introduce to you Mr. Kevin Richards, who will formally open this session, will formally open the webinar. Mr. Richards is and has been since 2015 the CEO of Kingston Properties Limited, with which I am sure you are all familiar. Kingston Properties Limited is a Jamaica Stock Exchange main market listed company, is multi-jurisdictional and a real estate company with assets in excess of $70 million, United States dollars, that is. In addition to his involvement with KPL, Mr. Richards is a real estate agent and sits on several other boards, including Money Masters Limited, John Robin Primary School, and today's Money Limited. In his spare time, he enjoys traveling, listening to music, and watching basketball and tennis when he has the time. Mr. Richards, without further ado, I call upon you to deliver the opening address.
Thank you for that gracious introduction, Afif, and good morning, everybody. Good morning to those who are joining via the internet or the Zoom platform, wherever you are, near or far. Pleasant good morning to you, and I want to express my appreciation to the Jamaica Developers Association for inviting me to deliver the opening address for this conference, which what I think promises to be a very informative and thought-provoking webinar. One of my own personal mantras is, never stop learning. And I think today we will learn a little bit more about contracts, joint ventures, and I'm particularly pleased about a discussion involving quantity surveyors. What we've seen is that oftentimes they are project sponsors who like to consider themselves as experts in specific areas and, will eschew the need for professionals because they believe they are experts. And I think it's very important that we discuss the role of professionals, and particularly quantity surveyors. So I'm very happy that that is going to be a focus of discussion today. I expect that all the presenters and the panelists, who are all experts in their respective fields, will do great justice to the focus topics today. So with that said, I will get into my very brief comments before opening this webinar. If you look at the real estate industry in Jamaica, there can be very little doubt that it has experienced tremendous growth over the last decade or so. And this is demonstrated with the growth in the level of GDP, and it's the contribution that the real estate and construction industry has made to overall national output. Currently, they contribute about 20% to overall GDP, according to Statin. With that level of significance, it is important that we recognize the need for more organization and more structure in the sector. And as time evolves, as is typical with anything, innovation will creep into the space, and there is going to be the need for us to evolve as we continue to grow as a sector. Now, when we talk about innovation, some people, may think of innovation in the form, particularly in the real estate sector, people may think about innovation in the form of innovative designs or modeling, climate-friendly designs, or some, new or cost-effective building techniques. But the area that I want to focus on today is on the area of financing, and specifically the area of innovation in financing of real estate projects. Often when persons think about joint ventures or joint arrangements, we tend to think of, a developer and a landowner coming together to create magic out of the ground. However, there are times when joint arrangements may exist involving financing partners. The real estate development projects, that are topic of discussion generally could either be what we call greenfield projects or ground up projects, or they could be value add brownfield projects. The sector has traditionally pursued the route of traditional bank financing as a financing option, as a means to grow the industry and to expand. But in more recent times, more innovative financial products have come to the fore and will provide participants in the real estate development industry with alternatives to traditional bank financing. While the industry develops and continues to move apace, legislation, however, unfortunately, is yet to catch up, and this delay continues to stymie the further growth of the sector. One such alternative financing option available is REITs. And obviously, I'd be biased towards REITs because of the industry that I represent. But REITs have been in existence in the US since 1960, when the US Congress passed REIT legislation in the US. And it has grown to a multi-trillion-dollar global industry. Now, what are REITs? A REIT, or a real estate investment trust, is an entity that is established to own or develop, oftentimes, income-producing real estate assets. And those are usually funded by a pool of investors. REITs allow micro-investors to own stakes in highly profitable real estate opportunities and ultimately benefit from the flows from those projects. REITs, like any other collective investment scheme, or CIS, are regulated and provide a number of features, the most notable ones being the tax efficiency in its structure and the ability to allow micro-investors to participate in the joint ownership of real estate assets. To maintain this tax-free status, REITs are required to distribute 90% of their taxable income to investors. REITs have grown to a size, as I mentioned before, a multi-trillion-dollar industry. The exact figure tied to the size of the industry is $6 trillion globally, and this is in the US and in nearly 40 different countries across Africa, Asia, Europe, and Latin America. REITs may be listed on a stock exchange or they may be unlisted, but they are still governed by specific rules. Kingston Properties, as I mentioned, the organization that I head, has long been an advocate for establishing REIT legislation in Jamaica, and we will continue that lobby. Countries such as Canada and Australia have adapted their previously existing CIS, or collective investment scheme legislation, to create their own REIT legislation. There will be no need for any groundbreaking development of new legislation, as a framework already exists with the current CIS legislation, which governs unit trusts in Jamaica. Notwithstanding the tax benefits from a REIT, given the level of regulations governing them, there would be greater accountability and transparency with the appropriate governance structures, which would provide assurances to investors and other stakeholders. Greater competition in the financing of real estate projects can be achieved not only through REITs, but also through more issuances of products such as structured notes, which are usually issued by regulated entities. More of these facilities could be instrumental in realizing a greater number of real estate development projects. Competition in financing of real estate opportunities redounds to the benefit of not only developers, but also the ultimate end users. Again, this will require the repealing or amending of dated legislation that is restrictive and primarily supports financing by deposit-taking institutions and allow for more innovative financial products to spur further growth in the real estate sector. One other area I'd like to touch on is the need for more public-private partnerships in real estate as a tool for urban redevelopment across the country. There are many swaths of underutilized lands or properties across the country that could be better suited for purposes other than what they're currently being used as. Professional valuers will tell you that land should be dedicated to its highest and best use, or HABU. Some may argue about the conversion of single-family properties to multifamily developments, but I leave that debate to others and for another time. Other people, when they think about joint venture, the first thing that there are joint arrangements, the first thing that comes to mind is thinking about residential developments, but this could be commercial developments as well. Take, for example, informal and unplanned housing settlements in some locations may be better suited for perhaps retail or industrial or multifamily development projects. These previously, or what would normally be a partnership between the private sector and the public sector, and the public sector in this case being the government, could ensure that some of these properties exhibit their highest and best use. One could think about the possibility of some of these lands, for example, being used for vertical housing developments instead of informal settlements to allow more persons to live closer to their places of work rather than endure long commutes daily, which drives down overall productivity. Urban regeneration projects have the potential to boost employment in many communities and could lead to greater tax revenues for the government. The partnership component to this is one that involves a combination of the technical experts, financiers, and the government, whose main contribution is the willingness to get it done. This will could unleash pools of capital locally and from overseas sources to transform the island. In closing, the spiritualist Hazrat Khan once said that some people look for a beautiful place, while others look to make a place beautiful. The combination of innovative financing options for real estate projects, along with exploring the highest and best use of properties, could achieve this end. I hope my remarks will generate more discussions around these topics, and I look forward to the presentations to come in today's webinar. Once again, I want to commend the team of the Jamaica Developers Association for always putting together high caliber sessions on the real estate industry, and also for its lobby work in facilitating growth of the industry. With that, I declare today's session open, and thank you for your time.
Thank you so much, Mr. Richards, for that very encouraging and very warm opening to this important webinar. I'm sure you've made us feel all relaxed and ready to receive the information that is going to be disseminated today. Before I introduce the next speaker, we need to go to a commercial break, and when we return, Stephanie Eubank will address us on a wide range of contractual topics.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
Solutions, support, service, security. DG View Security. See what you've been missing.
Smart AI video analytics with active detection for humans and vehicles, line cross detection, license plate recognition, face recognition, and specialized cameras. Full service providers in surveillance systems, access control, solar lighting, alarm, and smart home systems. Visit dgviewsecurity.com or call 876-906-6528 for more information.
For almost 40 years, the GEON Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The GEON Group of companies, creating homes that people enjoy.
JPS. I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket, don't stop it. Light up the path so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the path so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it done. Every night, every day. Bringing light to everyone.
Okay, welcome back, everyone. And as I promised before the commercial break, I would now like to introduce to you Ms. Stephanie Eubank, who will address us on the topic of some of the various contractual obligations involved in a successful development. In particular, contracts between developer and contractor, contracts between developer and purchaser. By way of introduction, Ms. Eubank is a partner in the distinguished legal firm of Myers, Fletcher & Gordon, and whose practice involves advising in and solving some of the most complex commercial issues. She has a wealth of experience in wide and varying aspects of the law of contract, and which experience adequately arms her with the necessary tools to address us on these important aspects of the land development process. She also has a passion for charitable projects, including teaching, technology, cuisine, and travel. It is my distinct pleasure to welcome Ms. Stephanie Eubank. Over to you, Ms. Eubank.
Thank you very much, Afif, and good morning, everyone. Thank you so much for having me. I am just going to quickly share my PowerPoint. So yes, I will be addressing contracts for developments. And of course, developments have featured very much, in the real estate industry in Jamaica in recent times. And of course, issues regarding developments have become a constant feature regarding our news cycle. We often hear about, various disputes regarding aspects of the development, how the works are done, whether they're completed within time, whether certain approvals and permits have been complied with, and to what extent a development is truly successful. Now, as a litigator, I often come in when things go wrong. And because I am exposed to when things go wrong and in trying to problem solve a situation or a dispute, it becomes even more apparent which clauses in these contracts are of particular importance and the types of precautions that should be taken by the parties to development contracts. One may look at a development site and see that, there are, the various aspects of the development that is ongoing. And of course, there are certain key players in any development project. This, of course, includes the developer, otherwise or often called the owner or the client or the employer. You, of course, have the architect or the contract administrator, which plays a very critical role in certain decisions that are taken in contracts between developers and contractors. In addition to that, you have the quantity surveyor, the main contractor. You may have subcontractors, and there is the engineer as well. Now, of course, one, looking into a development will kind of judge its success or failure based on what we see happening from the beginning to the end on the ground. But a lot of what happens on the ground is largely dependent on the nature of the contracts behind the scenes and the extent to which the parties are actually able to effectively and efficiently resolve disputes in order to actually bring the development to completion and to not have ongoing, long-standing matters that are not resolved and ultimately a failed development. Now, this chart provides a useful overview of just some of the different elements, looking at it from a bird's eye view of what really, goes into, or the different processes that come out of a contract between a developer and a contractor. Of course, you have the initial stage in which you have the formation, the inquiry, the tender, the negotiation, and all of those different features that lead to the actual formation and finalization of the contract terms. And of course, after that, you get into the stage of execution of the works. And this is where a lot of the problems start to occur, and where certain steps taken or certain positions taken in relation to the requirements under a contract can make a substantial difference in the success of a project. Some of the typical matters that are part of the execution of the works include, the variations, the measurements, the fluctuations, delays, extensions of time, access to the site, indemnification, etc., etc., and the list goes on. Anyone who has gone through any particular established standard form construction contract will know that there are usually many clauses in there, and some of them are very complicated. And, you know, just going through all of them, you may not get a sense of all the nuts and bolts immediately that come into making that contract and, you know, an operational part of the project. But that is why it's so important to go back to first principles and to really look at what are some of the key clauses and why these clauses are important in terms of flagging those areas that developers and contractors really do need to pay particular attention to. Of course, finally, in this flow chart, you get to a stage, you know, once the works are completed to a certain level, get to a stage of completion and assessment of defects, and hopefully, if everything goes okay, you get to a successful development and a completed development in which units can then be, you know, delivered to purchasers free from issue. Now, of course, locally and internationally, there are a number of construction contracts that can be used in terms of creating the terms between developers and contractors. However, there are certain standard form contracts that have come to be used quite frequently in developments in Jamaica. Firstly, of course, we have the local standard form of building contracts published by the Construction Industry Council, the most recent edition being the 2018 revision. And that tends to be used in a number of construction projects, particularly in relation to residential buildings and also commercial buildings as well, where, you know, there's a pretty much, I would say, you know, small to medium-sized developments. Most of the developments we see going on in the corporate area with apartment complexes or high-rise buildings going up, a number of them do use this standard form contract as the basis of their contractual obligations. In addition to that, however, you'll have other standard form contracts, such as the conditions of contract for construction by FIDIC. This is also used by players in the construction industry locally, and we tend to see this contract being used mainly in contracts for larger contracts for infrastructure work, roads, rehabilitation, and other major contracts for that type of construction. And so it's really a matter for the parties, of course, guided by, you know, experienced lawyers, to determine which standard form contract is suitable or best suited to the particular type of project and what the parties plan to achieve. It is never a good idea just to take up any standard form contract and just accept it or without any level of advice, you know, just go ahead with that standard form contract without knowing why or what these terms mean and what it will mean particularly for the development and how that progresses within the particular objectives that you plan to achieve. And so while, yes, these are standard form, a lot of important legal nuances go into negotiating these contracts and at times inserting particular conditions outside of the general conditions. And of course, also specifying certain deviations from some of the standard terms in the contract. So let us just take a quick look at the nuts and bolts involved in these standard construction contracts. Now, there are a number of topics covered by these contracts. And of course, in the half an hour that I've been allotted, there's definitely not enough time to go over all of the different variables that are in these contracts. And so we really want to focus on what are the nuts and bolts, what really makes the difference in your development project. You have scope of work, you have contract sum, of course, the payment schedule, the timelines, variations, and liability for defects. We're going to examine some of these in turn, but just to say that paying attention to the requirements for each of these different categories is critical in terms of ensuring that the development runs smoothly and that parties are all on the same page regarding the relevant legal obligations and what needs to be done in relation to any particular development project. Starting with the scope of work. Now, sometimes persons will brush over the idea of what is the scope of work. I mean, in fact, the works are very broadly defined at first in the articles of agreement, which is usually at the front of the construction contract. I will largely be focusing on the Construction Industry Council Standard Form contract for the purpose of this presentation. And if you look at the beginning of that CIC contract as I define it, you will often see that there's a definition of the works. And sometimes it is, it's just a general description, but importantly, it indicates that, the developer has caused drawings and bills of quantities to be prepared, which indicate the work that is to be done under the particular development project. Scope of work is not just a simple sentence or a general summary of what is to be done. It includes the type of construction, the required specifications, the schedule, the material and goods to be used, access to and logistics of the site, and other critical elements. It is clear that scope of work is really the foundation of the particular contract between the developer and the contractor, because there are many things that will ultimately flow from determining what is the actual scope of work. Once the architect prepares the drawings and the bills of quantity showing the work to be done and provides these to the contractor, it is then the contractor's obligation, as per clause 1, subsection 1 of the CIC contract, to carry out and complete those works in compliance with the contract documents in every respect, and in accordance with the directions and to the reasonable satisfaction of the architect or contract administrator. So this is a critical obligation of the contractor here. And so if there's any ambiguity, or if there's, if the scope of work is incomplete, then you can see from the get-go that there's likely to be issues in terms of interpreting what it is that the contractor is really expected to do. And this will have consequences when one comes to interpret other clauses in the contract, such as variations and extension of time. And, and that, of course, influences the flow of the development project and really whether it is that it really runs smoothly throughout without any significant legal dispute. So it's always important to ensure that the scope of work is complete and that it is specific and essentially is one where there is not much scope to argue that there is a particular element missing or that there are other works that have not been fully specified in those contract documents that are provided to the contractor. Now, on most occasions, I mean, given that this is the real world and things happen, when an architect provides drawings and designs and specifications at the beginning of a development project, the architect is looking at the project at that initial stage without factoring in some of the realities on the ground. And so it is not unusual for when the project starts to get off the ground and the contractor starts to implement the designs and the specifications and looks at the ground and looks at the features of the actual construction site, that there needs to be some adjustments to what those designs and specifications say. And so it is not unusual, therefore, for construction contracts to allow for variations. And our standard form CIC contract allows for variations, but of course specifies certain criteria that must be met in order to classify it as a proper variation, which triggers certain consequences under the contract. So just in broad terms, a variation is really an instruction by the employer, usually through the architect, to alter the works to be performed or to vary their timing, method, or sequence. Now, oftentimes, an architect may issue a particular instruction to vary the work or to vary the timing of the work. But not all of those instructions automatically mean that it is a variation under the relevant clause in the contract. And so it's not surprising that there have been disputes between parties and cases regarding whether the newly instructed work is in fact a variation, or if it really is just a part of the original scope of work. So now we see here an example of why the scope of work needs to be defined so clearly from the get-go, because the more ambiguous the scope of work is, and the less specific the contract documents are, is the more likely that one can get into this debate about, well, is this really a change, or is this just a necessary tweak to what was originally envisioned in the scope of work, or a gap that wasn't originally filled in the contract documents. And parties really do not want to get into those kinds of debates, because ultimately, as we will discuss shortly, these lead to debates about entitlement to extensions of time, questions of liquidated damages, and of course, the ultimate flow and time frame of the development project, all of which are, of course, critical to the parties involved, and which also have ripple effects ultimately to contracts between the developers and the purchasers at the other end of the spectrum. Now, of course, it's always useful to look at what are the components of a variation clause, just to kind of see what the criteria looks like and how it may be applied in real life. We're using here clause 11.2 of the CEIC contract as an example. And this clause actually specifically defines variation. That is usually the case in most of the standard form contracts. You will see a specific definition for variation for that particular contract, which will apply to your development contract. And so this relates to, in this case, the alteration or modification of the design, quality or quantity of the works, as shown on the contract drawings and in the contract bills, and includes. So you'll see 3 different items that are included here. You have the addition, omission, or substitution of any work. And you notice that we're not just here talking about adding work, but you're also talking about omitting work. And so there is the scope for an architect or the developer to actually take out work that was originally in the scope of works prior to that. Alteration of the kind or standard of the materials or goods to be used in the work, and the removal from the site of any work, materials, or goods brought on by the contractor. So there clearly is a very broad definition for variation, and it is one that can sometimes be fraught with controversy, because there often is a debate about whether this really is a variation under the contract and one which would trigger certain rights and entitlements under the contract. Now, this segues very neatly into the issue of delay and extension of time. Now, as one would imagine, in a development project, if there are a lot of variations to the scope of work, there's likely to be substantial delay. The time frame originally anticipated for the completion of the project is likely to be no longer possible, because there have been so many different adjustments to the scope of work and what the contractor is required to do. Now, of course, remember at the beginning of the presentation, I indicated that the contractor has this overriding duty to complete the works to the satisfaction of the architect. And so as variations continue to be issued throughout a development project, the definition of what the works are also expands. And so what the contractor is required to do under the project therefore becomes a different creature from what it was originally. So of course, the concept of extension of time then becomes very, very, very a very popular feature of development disputes, and can oftentimes lead to very protracted development projects, many of which we have all observed and seen and wanted to avoid. Now, clause 23 of the CIC contract speaks to extension of time. And a contractor can, of course, provided that certain criteria are met, request and obtain an extension of time to complete the works. Now, this is, of course, largely dependent on the opinion of the architect or the contract administrator. And you will see as we go through that there are a number of different reasons that the contractor can rely on in order to satisfy a request for an extension of time or to satisfy the threshold. Now, I'll just briefly go over some of them just to give an idea of how broad this clause can be, but of course to also highlight some of the pitfalls that can arise in interpreting and applying the extension of time clause. Now, force majeure, exceptionally inclement weather, and loss or damage occasioned by certain natural disasters. These are all, very typical conditions and reasons that a contractor may use. And of course, provided that he actually satisfies the threshold for these concepts, then, it stands to reason that the contractor would be entitled to an extension of time, provided that there are no other factors that detract from the contractor's entitlement. Of course, often in looking at force majeure, for example, you have to show that the circumstances are unforeseeable, that they're of an exceptional nature. You will note that the term force majeure is not specifically defined in the CIC contract, and so one will have to have reference to the common law in order to determine what really falls within the force majeure anticipated in this particular clause. But there is no doubt that force majeure is generally limited to exceptional circumstances, which are not reasonably foreseen. And so often the foreseeability of some of these disasters and contingencies ultimately become critical to the question of whether a contractor can reasonably rely on that basis in order to obtain an extension of time. Now, to give other examples, you of course have civil commotion, strikes, national or regional building industry disputes. And you'll see in the third item here, which we were discussing before, instructions issued by the architect under certain clauses such as variations. Now, again, this shows you now the interlink between variations and extension of time. And so if it is that a particular instruction from the architect, which somehow changes or adjusts the scope of work, is considered a variation, and the contractor is somehow, therefore, in a situation where he can no longer complete a part of the work or the overall works by a certain deadline, then the contractor will often seek to argue that this variation has essentially entitled him to obtain an extension of time from the developer. And so it is very critical then to determine whether an architect's instruction is really a variation or it is not. Because if it is not a variation, then of course the contractor cannot rely on this particular reason to obtain an extension of time. And if there is delay, the contractor may be liable for liquidated damages in relation to the developer and in relation to the delay caused by the contractor. Now, of course, it's also important to bear in mind that even in looking at some of these reasons, even the ones previously discussed about natural disasters, civil commotion, industry disputes, etc., in all of these conditions, there is always the exception, of course, that any matter that is caused by the negligence of or failure of the contractor obviously would not qualify for an extension of time under the contract. And so that is always an understood exception in relation to that. And of course, it's important for the contractor to receive all the instructions, the drawings, the details, the levels from the architect in due time. And so again, we go back to the scope of work and whether you get everything at the beginning and whether those documents are actually complete and can be smoothly implemented in relation to the actual construction process. This will often determine whether the development really does, progress in the manner anticipated by the parties. Other reasons include acts or defaults of nominated subcontractors, suppliers, artists, tradesmen, and other persons engaged in other works. And also if an inspection is done and you're opening up work that has been covered up by the contractor, or testing the work, delay caused by that would also be covered by an extension of time. We also see other reasons here, including the contractor's inability for reasons beyond his control to secure labor, goods, materials, equipment, etc. for the proper carrying out of the work, compliance with the architect's instructions regarding antiquities, and failure of the employer to pay the full amount certified by the final date for payment. So in summary, you will see that there are a number of reasons under the standard form CIC contract that would entitle a contractor to obtain an extension of time. And of course, if you are a developer, you want to ensure that the circumstances in which a contractor can delay and rely on an extension of time are limited and are kept within strict bounds so as not to unnecessarily delay the overall completion and success of the development project. But at the same time, of course, the rights of contractors have to be equally balanced against that consideration, because in certain circumstances, there are justifiable needs for extensions of time to be granted. And as we have been seeing, the role of the architect or the contract administrator is particularly critical because a number of decisions taken by that person, including varying the scope of works, often has that domino effect as to which party ultimately bears the responsibility for or the sacrifice for the delay caused by certain decisions taken in the project. Now, what happens if the extension of time clause is satisfied? The architect then has to do two things. The architect has to estimate the length of the delay, and he has to do so within a reasonable time. And the architect also has to make a fair and reasonable extension of time in writing. And notice that it says the extension has to be fair and reasonable. So the architect is therefore tasked with looking at the circumstances, the reason or cause for the delay, the extent of the delay, and all of the surrounding features to determine what is really a fair and reasonable extension of time. And so that is, of course, a very critical responsibility of the architect in the development project, and it can ultimately play a substantial role if it is that certain disputes arise regarding whether the extension of time was really fair and reasonable in the circumstances, which often is a very fact-specific exercise. And so it is critical that these decisions are made objectively and based on all of the relevant available surrounding facts. Now, ultimately, while we often see a lot of these delays and extensions of time occurring in a development project, it is very important to emphasize that notwithstanding a contractor qualifying for extension of time, there is always the overriding duty of the contractor to use all best endeavors to prevent delay and to do all that is reasonably required to the satisfaction of the architect to proceed with the works promptly. And so an extension of time is not a reason to go at a certain pace or at a pace that you think is appropriate if you're a contractor. And so even if one qualifies in a particular instance for extension of time, that doesn't mean that you're going to continue to qualify for an extension of time. And everything is assessed based on the particular issue that arises at each particular point of the development project. Now, of course, the project progresses through the execution phase. The contractor completes various aspects of the works. And then we get into whether practical completion has been arrived at, and of course, most importantly, whether there is liability for defective work. This is usually a central feature of a number of disputes that are arbitrated or litigated between parties. The contract will usually specify what is called a defects liability period. Now, there's no magic to this period, and the parties, of course, are expected to negotiate and agree on a particular time frame. But if there is nothing stipulated in the appendix to the CIC contract, then 6 months is the default period, which starts to run from the date of the certificate of practical completion of the works. So it's very important to pay attention to this, because there's no one size fits all when it comes to a particular construction contract. Development may be particularly large or have certain foreseeable challenges based on the nature of the development that may warrant a longer defects liability period than the standard 6 months. On the other hand, there may be a development that's particularly simple or is, not really expected to have many challenges or nuances that may play a role in terms of remedying defects and the time frame, etc. And so you may then prescribe a shorter defects liability period of, say, for example, 3 months. So you sometimes see different periods in the appendix, but generally speaking, parties tend to just go with the default 6-month period in the standard form contract. Now, practical completion is really what triggers the start of the defects liability period. And so the question of, well, what is practical completion? I mean, we are, of course, all familiar with that. If there's one thing persons always speak about and parties always look forward to, is the certificate of practical completion. But of course, even that is riddled with disputes oftentimes. Clause 15.1 of the CIC contract stipulates when practical completion occurs, and that is essentially when the architect believes that the works or a section of it is completed sufficiently to enable the developer to actually utilize the works. And in the process of giving this certificate of practical completion, the architect has a certain responsibility in terms of specifying the defects that the contractor is required to remedy. Now, this is where a lot of the disputes and the problems start regarding this type of liability. Now, of course, when one inspects a particular project, a particular construction site, etc., there are some defects that you will automatically see from a reasonable inspection using due diligence, and there are those that you won't immediately see. Now, the architect will usually attach a schedule of defects, sometimes called a snag list, to the certificate of practical completion, which lists various aspects of the building or or whatever is being constructed that needs to be addressed by the contractor. And this now is what forms the focus of what has to be done in the defects liability period by the contractor. The contractor is clearly required to make good these defects, shrinkages, or other faults within the defects liability period. Of course, there may be disputes between the contractor and the architect as to whether these really are defects, shrinkages, or other faults. And you will often see that there are negotiations and discussions occurring sometimes regarding certain items that are on the snag list that perhaps maybe the contractor does not believe is really a defect resulting from the work being done by the particular contractor, but is really due to some other matter that has occurred that has nothing to do with the contractor's workmanship or the actual progress of the contractor in meeting the specifications and the designs and the drawings provided by the architect. And so there is that dispute regarding whether these truly are defects that the contractor is required to remedy. But beyond that, one has to look to the overall potential scope of liability under the contract. And that is often not limited to the defects liability period. And the reason for that is that we get into this debate oftentimes about patent versus latent defects. And when you have obvious defects that you can discover on inspection, as I indicated earlier, of course, those are going to be included on the schedule of defects. But when you have a hidden defect, a defect that is in a wall or a very obscure or hidden leak that doesn't become apparent until there's heavy rainfall, or you have termite infestation, which is clearly not apparent
more than one person around the thing
in relation to the particular building, or other types of defects that one cannot easily look at and determine and discover in the scope of the inspection, then you get into the issue of latent defects, and a contractor will have a hard time hiding behind the defects liability period or using the end of the defects liability period to say that, okay, well, I am not required to rectify this defect because you didn't tell me about it in the defects liability period, and so that's the end of my responsibility. A lot of the dispute and the debate about what the contractor is required to do and fix often comes down to this whole patent and latent defect debate. And so this is why it's very important to ensure that when there are inspections done in a particular development project, that one really does document clearly what is inspected, what efforts were taken to really properly look at and examine the premises, you know, showing the dates on which these inspections were done, what was said, what was seen, taking pictures. Contemporaneous pictures are particularly important because ultimately when you get into a litigation matter where you're trying to argue whether the defect could have been reasonably discovered, a very important piece of evidence is going to be what did the site look like at the time, what was actually seen by the parties that were inspecting the premises, and can this really be seen or said to be something that could have been discovered with reasonable due diligence. And ultimately, you want to ensure that you are on the strong side of resolving that dispute. Otherwise, you are essentially left holding the bag because you then may be overcome by an argument that this is a defect that you ought reasonably to have informed the architect of, or that the architect ought to have specified and told the contractor to remedy during the defects liability period. And so this is really, you know, I would say the nuts and bolts of what tends to happen regarding disputes on defects and where the liability for that lies. Now, very briefly, in the 1 minute I have left, I want to just briefly touch on developer and purchaser contracts. Of course, some of the key features in these contracts, especially in pre-construction contracts in particular, is the concept of escalation. And of course, it is one of those provisions that are heavily negotiated and debated at the time of negotiating the contract terms, because of course it allows for an increase in the price due to the various fluctuations that may arise for labor and materials used in the project. Now, oftentimes the parties will agree to a cap on the escalation, and the amount of that cap is of course very critical because it determines whether or to what extent a developer can properly increase the price that the purchaser has to ultimately pay after the construction is done and the unit is ready to be delivered. Sometimes these contracts will also include the plans and the specifications and details as to what the units are supposed to look like. Of course, the level of detail may vary depending on the particular developer, depending on the contract, etc. But of course, it is very important to keep to these plans and specifications because ultimately you may end up having a dispute and ultimately getting into litigation when the purchaser receives the unit and there are a number of defects and missing aspects of what you said the plans and the features of these units were to include. So that is particularly important, that that is clear and unambiguous. And of course, ultimately, that when the developer is entering into its contracts with the contractor, that there's a level of consistency and clarity regarding what each party is required to do and what ultimately is the objective in the development project and what are the specifications of the ultimate final product that the purchaser is expecting to receive. Defects liability, which we just spoke about regarding developer-contractor contracts. Of course, this is also relevant to developer-purchaser contracts. There will often be a defects liability period specified in these contracts as well. The purchaser is expected to inspect the unit to look and see whether there are any obvious or other defects that could be identified by reasonable due diligence, and to inform the developer of these so that these can be fixed. Again, we get into the debate about patent and latent defects. And so ultimately, very important to be very meticulous and to ensure that all of these different processes are documented and that clear correspondence passes between the developer and the purchaser in relation to what is seen on the ground and what is being demanded and requested in terms of remedying these defects. And of course, the timing of all of that. Finally, of course, there's often a debate about whether time is of the essence. This is often a regular debate in any agreement for sale. And so oftentimes the developer will want to ensure, or the parties there may be a dispute about whether they want to make time of the essence from the get-go, including it as a clause in the contract when it is executed. But even if it isn't, as you know, of course, you can always make time of the essence at a later stage. But again, ultimately, the objective is that you want to try and make sure that the timelines are held or considered seriously and that there isn't much delay in terms of getting to the point of completion of the sale transaction. And finally, I definitely don't want to bore anyone. And so I try to really focus on the nuts and bolts, and I'm sure that we will get into some more of the specifics in the Q&A session. Thank you very much for having me, and I really look forward to discussing some of these issues with you. Over to you, Afif.
Carolyn, thank you very much indeed for that wonderful presentation. It certainly was very, very detailed and very clear, and I enjoyed it very much indeed. You touched on the very sensitive and salient points that arise in these circumstances. Thank you very much indeed. We will now go to a commercial break afterwards, and when we return, Stephanie will be joined by, we're hoping to have her be joined by two panelists, one being Ms. Carolyn Chuck and the other being Mr. Noel Levy. However, Ms. Chuck is ill and unable to join us for the Q&A session, even though I know that she's looking on. So Mr. Levy will be the only panelist there after the commercial. So let's go to the commercial break, and when we come back, we'll deal with the Q&A session.
JPS. I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket and stop it, light up the path so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the path so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it done. Every night, every day. Bringing light to everyone.
For almost 40 years, the Geon Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The Geon Group of companies, creating homes that people enjoy.
Solutions, support, service, security. DG View Security, see what you've been missing.
Smart AI video analytics with active detection for humans and vehicles, line cross detection, license plate recognition, face recognition, and specialized cameras. Full service providers in surveillance systems, access control, solar lighting, alarm, and smart home systems. Visit dgviewsecurity.com or call 876-906-6528 for more information.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
Welcome back, everybody. We are now welcome into the Q&A session on the presentation by Stephanie made earlier. And as I mentioned before, there were supposed to be two panelists, but unfortunately, Ms. Carolyn Chuck is not well, and we wish her all the best and a speedy recovery. But before I introduce Mr. Noel Levy, who is the other panelist, just let me remind you that in order to ask questions and so on, you have two options. One is to use the Q&A icon at the bottom of your screen and type in your question. Or if you want to be heard, you can raise your hand and our technical team will allow you in to ask your question. But before we proceed further, let me introduce to you Mr. Noel Levy, who is no stranger to this area of the law and who comes to us with his vast years of experience in commercial law, as well as several other areas of the law. Noel was a partner at the firm of Miles Fletcher and Gordon from 1974 to 2009, and since that time has joined the lowest team of consultants, but is still a valued member of the firm. We welcome Noel, and I was going to ask when we had two panelists who comes first, but before you start, Noel, asking your questions and so on, there are two Q&As in the area, and the first one says, "Good morning. What is the position on insurance once the development is completed? Who bears the responsibility for insurance up to the time of sale of the units?" And they're both anonymous attendees. And the other question is, can a vendor, after requesting a specific extension of time to an undertaking issued by a mortgage institution, then in turn issue a notice to complete within the 14 days to a purchaser that will expire even before the stipulated undertaking deadline? Having not yet met the conditions that undertaking to facilitate final payment, I'm not sure I understand that, is the purchaser then liable under such a circumstance? Those were two questions that were in the Q&A chat group, and I don't know if you want to address any of those, Stephanie, before we bring in Noel.
Okay, thank you, Afif. Good morning, all. The two questions that have been asked really are for conveyancers, and that has never been my forte. I will, however, attempt to answer them as I see it. The second one, I think, is a little too complicated to be answered. It has too many different moving parts to it. But the first one, my understanding is that unless there's an agreement to the contrary, after the agreement for sale is signed, the property is at the risk of the purchaser, and that the purchaser should get out insurance to take out insurance in the event of any loss or damage. I know that it is a practice today to leave that with the vendor. I believe that creates problems of its own. But as far as the law is concerned, it was my understanding all along that that is the position.
Karen, you want to, sorry, Stephanie, you want to comment on that?
Well, I agree with what Noel has said. I would just add that, of course, my area of practice is litigation, and so I really do focus on a number of the disputes that arise in these contracts. And of course, I don't really practice per se in the area of conveyancing. And so I would, of course, field those types of questions to the other panelists who do practice in that area. I mean, not including Noel, but he still has that that knowledge. Afif, I do notice that there's another Q&A question that has come up in the question and answer section.
Yes, I haven't dealt with that one yet. But I think this is perhaps the time to do it. That second question is a bit complicated. I agree with Noel, and really needs quite a bit of time and clarity to really deal with the issues raised properly. The third question is from Mitzi Dillon, who says, and the vendor in this case is a housing development company. Well, I don't know if that is, I'm not sure whether that is a question or a statement of fact. I don't know. But there's one from Tessa Sewell. From experience in the US, developers allow 1 year for defects and liability period. What is the standard period for defects and liability to be dealt with in Jamaica? I think you answered that, quite frankly, during your dissertation. It's 6 months, or unless there's a contractual amendment to that.
Yes, indeed.
Yeah. I see a hand up. Alton Morgan is up. Could the technical team allow him to ask his question? Unmute. Yeah, you're unmuted.
Can you hear me? Okay, yes. Just to amplify a bit, the answer which Noel gave is correct, that the purchaser must arrange their own insurance once the sale is completed. But there's an exception to it. While the premises are under construction agreement, it is the contractor's insurance which operates, and the practice in the insurance industry, which I was exposed to for some time, is that they won't allow double insurance coverage, so that the purchaser is not able to insure while the place is under construction, because it's already covered by another policy. But once it's completed, once practical completion is certified, then yes, the purchaser must arrange their own insurance.
Yeah, thanks a lot, Alton. You could take down the hand, so don't call on you again unless you really want to come back. Yes, any other questions from the audience?
Yes, I just wanted to make a bit of clarification, Afif. Alton is perfectly correct. The point I made wasn't necessarily with respect to contracts in which the purchaser has entered into with a developer where it is expected that a building will be constructed. I was merely saying that once you enter into the purchase and sale agreement, unless there's a provision to the contrary, the risk passes to the purchaser. But I understand in most of the contracts today, the vendor assumes the risk, because I believe it is that the purchaser refuses to take out insurance. Perhaps that's the easiest way to avoid a problem before completion.
Yes, true. Any other questions or any I see Veronica's hand up. Veronica Royal, could you let her in?
Good morning, everyone. I just wanted to add to something that was said, and that is why it's important when you have a delay, which was discussed before, that Stephanie discussed. It is important that it is tracked whether or not the insurance for the construction by the contractor or the developer is also extended, because when you initially take out that insurance, it's normally for a particular period. So when the job is delayed, you may very well end up finding that the works are not insured. So it's important that that aspect of it, as you track the delay, the insurance is also tracked. Thank you.
Yes. Agreed.
Agreed. Very important, Veronica.
Very much so. I see Yolande Mullings has her hand up. Can we deal with that? Yes, Yolande. Can you unmute and?
Hi, I'm sorry, that was an error. I apologize.
No, John Mark Parkinson's hands is up.
Yes.
Yolande, could you remove the hand, you're right, the Parkinson?
Yes, hello, good morning. Are you hearing me?
Morning.
Yes, so my question is in regards to the extension of time, and in the occurrence of force majeure. I wanted to know who would bear the responsibility of the expenses incurred by the contractor during that time, and would that form part of the contractor's claim for extension of time?
It usually is an event where each party to the contract absorbs the risk. The contractor is not usually entitled to, and certainly not under the CIC contract. The contractor is not entitled to loss and expense. But the owner, the employer, bears the loss of time on the project, because that has a monetary value. You can monetize it.
Okay.
So extension of time is granted.
Yes.
But there are no liquidated damages payable.
Right. You happy
Yes,
with
and
that?
essentially it precludes the contractor from having to pay that liquidated damages to the developer for the additional time and the delay in the overall development project.
Right, correct.
Okay, thank you.
On the Q&A icon, we have a couple more questions. One from Carl Watts. When an architect's instructions are deemed to be a variation, is that reflective of oversight by the architect or incompetence?
Could you repeat that question for me, Afif?
When an architect's instructions are deemed to be a variation, is that reflective of oversight by the architect or incompetence?
Well, that really is a very difficult question, because there are obviously cases in which variations are required for a variety of reasons. But there are cases in which the architect has perhaps failed in providing proper drawings, etc., etc. The contractor doesn't bear that risk. That's a risk that the owner bears, and I think that would go back to the arrangement between the architect and the owner, employer, developer. What I suspect happens in most cases, and that simply gets passed on to the purchaser, which is unfortunate.
Any comment on that, Stephanie?
Yeah, I agree with what Noel has said. I mean, I would just add that it is not automatically an indication of incompetence on the part of the architect. There may be certain unforeseen aspects of the construction works that arise in the course of the development project based on the on-the-ground circumstances, that therefore require the architect to issue certain instructions to adjust the scope of work to meet those realities on the ground. And so it's really a case-by-case assessment as to what the nature of the variation is and what the reason for that variation is.
And there are a lot of variations that don't attract any cost to anybody. It may be easier way to do the work, or sometimes the contractor has a problem and he wants the architect to help him find a solution. But it's very difficult to have a contract with a fairly complex building, particularly when you may have delays in delivery of materials, you have delays in how you're unable to find enough workmen for which the contractor is entitled under this contract to loss and expense. Very often you have changes that have to be made given the circumstances. And of course, if you have force majeure events and events like that, you will also have changes that have to be made, whether it's a matter of time or it's a matter of how the work is to proceed. Because work can go on if you don't have certain materials, but work can't go on if the materials are fundamental to the works at a particular stage. So you'll always have, in a building contract, you'll always have events that will require the architect to take decisions with respect to the contract that may result in a variation that has nothing to do with what the architect has done as far as the drawings are concerned.
Yeah, I totally agree with that, Noel. I agree with that. There's also a comment, I'm not sure if it's a question, it's a comment from Woodrow Whiteley, which says, regarding the insurance risks, it is very often the case that completion of sale agreements are normally later than end of practical completion. This may be significant. And we also
I think if I may, Afif, I'm not sure that people really sufficiently address the problem. What would happen is that in 99.9% of the cases, there's no need to ask to call on the insurance. But I don't think people really look at very carefully at what stage who is to insure what. And if it is a case that the purchasers ought to be fully protected and not have something intervening, then one would want to go to the situation where the developer would be obliged to carry the insurance until completion, which is what I understand happens in any event in normal sales of houses and the like today. If nothing is done, as far as that is concerned, it is my understanding that is the purchaser's risk. But it may be something that needs to be carefully looked at in a number of contracts. And by the way, I just, as a matter of observation, noted, and I thought it was of interest, that the form of CIC is issued under the sanction of the Jamaica Institute of Architects Incorporated, Master Builders Association of Jamaica, the Jamaica Institute of Quantity Surveyors, the Institute of Engineers Jamaica, but the Jamaica Bar Association has nothing to do with it. So I assume lawyers are not important in the process.
We never are. There's also another question from anonymous attendee, which says, since the CIC standard form of contract speaks specifically to defects that appear within the defects liability, would the issue of latent defects be applicable under a CIC contract? That's a sticky one. Alton, would you like to comment on this one? I see your hand up.
Okay, yes. And I think Stephanie may be familiar with the Court of Appeal decision, McNaughton versus Dumay Global Development and others, where the Court of Appeal differentiated the contractual restriction on defects period from the common law principle in tort. that the right to bring action in relation to a latent defect starts from the time when the defect is discovered. So that essentially the CIC contract would not cover a latent defect, which may manifest itself many years after the construction is completed.
Yes, exactly, Alton. And therefore, one would not be limited by the 6-month period in the CIC contract in terms of the contractor's obligation to remedy the defect. Because if, for example, this latent defect, becomes apparent a year, 2 years, 3 years, 4 years after the construction has been completed, then that is not restricted by the defects liability clause of the CIC contract and would form an independent cause of action under the common law that, that the contractor could be found liable for independently of the CIC contract.
And the period of time would depend on whether the contract has been executed under seal.
Yes.
But it's 6 years or 12 years.
Yes, exactly. So it would be just dependent on the relevant limitation period to that particular cause of action.
But there are contracts in which it's made very clear that after a particular date, the intention is of the parties that there will be no liability or otherwise.
Yeah. Before I go back to the Q&A sessions, I see Veronica's hand up. Veronica, you want to say something on this issue?
Good morning again. Yes, I wanted to just point out that the CIC form of contract with respect to that defect liability period, we often explain it to contractors that it's tied to the retention fund. And it is that period of time when, as Stephanie has pointed out, when the defects that they can be readily seen, of course, the developer, the client has money in hand where they can actually use it to remedy those defects if the contractor doesn't do it. So it is at the end of that period that that retention fund is released, but it does not take away the client's right in common law to pursue other defects that are discovered outside of that period that could not have been discovered, which means the client could have remedied it if it was discovered. So it is just there for that defect liability period where the client can't hold on to that retention fund beyond that period, which was agreed.
Yeah. Question, of course, arises, and I've seen it, where the retention runs out and all the defects have been identified prior to that. So that's another issue again, which goes on. I think that's going back to common law now, probably. Thanks very much, Veronica. On the there are some other Q&As. We're running out of time on this one. We only have a short period of time left. An anonymous attendee. Does the scope of work include a detailed list of activities and implementation schedule? That I'm not sure any of us can answer that one. You have a comment on that, Stephanie? Scope of work is scope of work, which is contractual, and
yes,
I don't think anybody can answer that in the blue just like that. And
it would depend on what the parties have agreed to, and what the level of specificity that the parties would like to have the scope of work be defined as or provided for in the contract.
Yeah. And then when does time begin for a defects period in a case where the CPC is issued before physical possession is given?
Practical completion.
Yeah.
I think they issued a practical completion certificate.
The date of the certificate.
Yes.
The practical completion certificate, I think, would be the beginning of that.
Yes.
And another one, with respect to the period stipulated in law, can a contract exclude or override such stipulated periods? In other words, if the time has run out for under the law for making claims, could it be altered by contractual agreements?
I think the answer to that is it's really the question seems to have been asked unusually the other way around. I think the answer to that is yes. One can always agree that the statute of limitation shall not apply, and that something can last for a longer period of time. But normally it's the other way around. How early is it that the parties get released from obligation to the other?
Yeah.
Usually that's.
Yeah. I have another question. If completion date of the project is delayed for any of the reasons listed under the standard form of contract, and the cost of construction increases within the extended period, will the purchaser still be liable to pay for escalation?
The answer to that seems to me to be yes. It falls within the contractual period, and there's no restriction on what I think would fall under fluctuations. If it is that you had in the contract something that said any increase in the price of materials before 12 months in the contract, then that may be another issue to be addressed.
Yes.
But I think you have to restrict the period of time. Otherwise, it will normally flow as being a part of the time for completion of the contract.
Yes, and of course, it would also depend on the particular terms in the agreement between the developer and the purchaser, and how that clause is negotiated, and whether there are certain other limiting factors that are included in that clause that would somehow help to limit the scope of escalation arising from those delays.
Well, thank you very much.
You could have a situation, that's one thing, following up on Stephen, you can have a situation in which the developer has decided vis-a-vis the purchaser that the cost to the purchaser is fixed. That doesn't mean that fixes the entitlement of the contractor. But I think that's a good note to end on, Afif. That's how I see it.
Yeah.
The two different contracts.
But thank you very much, Stephanie. Thank you, Noel. Thank you for all who participated in that. Time has caught up with us. So it has been a very, very interesting discussion. We could go on for a little while more, but unfortunately we are constrained by time. So thanks once again. And we'll now take a commercial break, after which we will come up with the next paper by Mrs. Leisha and Smith. Thank you very much.
Thank you. Thank you, Afif.
Thank you, Afif,
Thank you
and
all.
thanks everyone.
Right. We take the commercial break now.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
Solutions, support, service, security. DG View Security. See what you've been missing.
Smart AI video analytics with active detection for humans and vehicles, line cross detection, license plate recognition, face recognition, and specialized cameras. Full service providers in surveillance systems, access control, solar lighting, alarm, and smart home systems. Visit dgviewsecurity.com or call 876-906-6528 for more information.
I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket and stop it, light up the part so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the part so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it's done. Every night, every day. Bringing light to everyone.
For almost 40 years, the JDA Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The JDA Group of companies, creating homes that people enjoy.
Welcome back from the commercial break, and we continue the webinar with a presentation on joint venture contracts and the issues arising therefrom. And it is then my very pleasurable duty to welcome Mrs. Leisha Ann Smith, who is going to present the paper on this topic. Now, Mrs. Smith is a partner at the legal firm of Eunice Schofield Dillon and Company, which she joined in 2003. And she practices in the conveyancing and probate department, in which she has gained substantial experience in the handling of the many complex issues arising from these matters. Presently, she represents one of Jamaica's leading residential property developers and is the firm's representative, that is Eunice Schofield's representative with the Jamaica Developers Association, as well as that association's representative with the PSOJ. Welcome, Mrs. Smith, and we look forward to your presentation.
Thank you very much, Afif. Good morning, everyone. Okay, I'm going to just try to share my screen quickly. Right, so I hope you are seeing my screen. So the topic, joint ventures and issues arising. This is not a discussion of the exact terms that are usually in the joint ventures, but it refers to what has been happening recently and hopefully will clarify some of the misconceptions or misunderstandings that there may be regarding exactly just what a joint venture is. Okay, so where to begin? I've started at just what is it? So according to dictionary.law.com, legal dictionary basically, a joint venture is an enterprise which is entered into by two or more people for profit for a limited purpose, such as purchase, improvement, and the sale or leasing of real estate. A joint venture has most of the elements of a partnership, such as shared management, the power of each joint venturer to bind the others in the business, division of profits, and joint responsibility for losses. However, unlike a partnership, a joint venture anticipates a specific area of activity and or period of operation, so that after the purpose is completed, bills are paid, profits or losses are divided, and the joint venture is terminated. So from a general standpoint, a simple definition is that a joint venture refers to a business arrangement in which two or more parties pool resources in order to be able to achieve a common objective. It is typical that each of the participants in a JV, joint venture, will be responsible for the profits, losses, and costs which are associated with it. However, the venture is usually its own entity, separate from the participants' other business interests. In fact, most of the available literature surrounds joint ventures in commercial business transactions, which can relate to any type of business undertaking. So what I did was to look at different types of joint ventures. Now, there are some jurisdictions in which there are specific legislative provisions regarding the implementation of joint venture agreements and which provide the regulatory framework for their use. These legislative provisions define a joint venture as a business agreement in which the parties agree to develop for a finite term a new entity and new assets by combining equity. Various categories of joint ventures are created, and the legislation is aimed at providing for the implementation of joint venture agreements, establishing governing rules for public-private partnerships and public-private procurement processes, as well as supporting major investments across various sectors. In her article on joint ventures in 2016 in Australia, Alice Hayes, a then senior associate with law firm Corres Chambers Westgarth, pointed out that the term joint venture has no settled meaning in Australian law. Essentially, there's no set definition by legislation. She indicated that when an issue arose in the High Court of Australia in determining whether a relationship was a partnership or a joint venture, the High Court noted that key features of a joint venture include working towards a common aim where the parties each contribute money, property, or skill. Unfortunately, or fortunately, similarly, in Jamaica, there are no specific legislative provisions which speak to joint ventures and their implementation. However, there are various documents, so government policy documents relating to the issue of public investment and the use of joint ventures in the process. For instance, there's a strategic public sector transformation project and the use of public-private partnerships via which the government of Jamaica engages private stakeholders or entities to achieve certain objectives. This has been seen in respect of the Sandster International Airport, the Jamaica Private Power Company Limited's power plant in Rockford, and the construction of Highway 2000. According to Investopedia, a joint venture can be short or long-term. It can be formal or informal. It can result in the creation of a separate entity, such as a limited liability company or a partnership, or it can operate jointly as two separate entities. Frequently, resources and expertise will be combined so as to result in cost savings for the enterprise. So, what is it that has made joint ventures so popular, especially nowadays in our context? Anirudh Singh Chauhan, a research analyst, opined in his article on the proliferation of joint ventures in India that it was seemingly as a result of the passage of the Indian Real Estate Regulation and Development Act of 2016, as well as the subsequent formation of certain real estate regulatory authorities, which were tasked with the responsibility of regulating real estate development and bringing transparency and accountability into the real estate sector there. He surmised that the regulatory regime implemented strict regulations, which made it difficult for small developers to comply with the stringent regulations within the industry, and that those who could not survive either went into bankruptcy, and those who wanted to be able to survive formed joint ventures with big developers. So for him, essentially, joint ventures are essentially a way for someone to match capital, which is needed or desired for a real estate acquisition or for a development by an operating party with a real estate capital provider. This is what Thomas G. Myra of Reed Smith LLP indicated in his article, Understanding Joint Ventures. He says further that the respective economic interests of the parties to the joint venture agreement will often directly correlate to the respective percentage of capital contributions made by each party. For me, this is suggestive of the reason for the notable increase in the use of joint ventures in the Jamaican context. Rather than expending capital, which is not necessarily readily available, to purchase land to then implement a development, savvy developers have managed to make attractive offers to persons who already own parcels of land, which can be easily utilized for implementing a development. According to Safia Rainier, in her article published on HubSpot.com, some of the advantages of joint ventures include the ability of the parties to pool their resources, while at the same time sharing the risks and benefits to be derived from the project, as well as increased speed in getting the project to the market. On the other hand, the disadvantages include the possibility of one party not upholding his or her end of the agreement. There may be disagreements between the parties, resulting in the project being delayed or not completed, and there's also the possibility of unbalanced power dynamics. So, what's the big fuss about? In recent times, frustrated purchasers and other affected parties have increasingly put pressure on developers regarding issues arising from real estate developments. Regulatory bodies have quite frequently scolded real estate developers for delays in project delivery, which, according to High Peaks Capital in its blog, has resulted in the consumer-centric regulatory regime pushing developers to form joint ventures as they provide tremendous flexibility in the pursuit of real estate deals. They allow parties to execute deals collectively that they could not individually and are an effective means of pooling capital. With the various issues which have arisen recently, certain questions therefore arise, namely, what are the risks of entering into a joint venture? And simply, is it worth it? The short answer is that it depends. In the recent case of Caribbean Real Estate Investment Fund against Valerine King, which was initially at first instance in the Supreme Court and later, just this year, in the Court of Appeal, the court was tasked with, among other things, reviewing the terms of a joint venture agreement which was entered into between a landowner and a developer. Now, briefly, the facts of the case as set out in the judgment of the Honorable Mr. Justice P. Brooks are as follows. The parties signed the joint venture agreement on November 13th, 2006. By its terms, Mrs. King was to supply the land that she owned, and Caribbean Real Estate Investment Fund, CARIF, was to supply the financing and logistics for developing the land to provide a mix of commercial and housing units. Mrs. King was to be paid the value of the land, and she was to have a share in the profits from the sale of the units in the development. On January 28th, 2007, so about 3 months later, Mrs. King sent a letter to CARIF terminating the contract. Apart from a tirade by telephone from CARIF's principal, Mr. Anthony Tharp, as was indicated in the judgment, on the day following the issue of the letter, Mrs. King said she heard nothing from CARIF until approximately 4 years later. On January 11th, 2011, CARIF wrote to her indicating that the development had stalled because it had not yet received the registered title for the land. CARIF urged her to produce the title, but Mrs. King did nothing about the matter. On January 28th, 2013, so approximately 2 years thereafter, CARIF filed the claim on which the Honorable Mrs. Justice Tai, acting as she then was, eventually ruled. So the essence of the dispute between the parties was that Mrs. King insisted that she was only interested in selling her land, and that was the verbal understanding between CARIF's representative, Mr. Donovan Gooden, and herself. She asserted that although she signed the joint venture agreement, she was not comfortable that it met her needs, and she later decided that she did not want to do business with CARIF. In her defense to CARIF's claim, she also contended that the agreement was unenforceable as being uncertain and in breach of the Real Estate Dealers and Developers Act. CARIF, on the other hand, contended that the joint venture agreement was clear in its terms and that it was not a sale agreement. CARIF asserted that the joint venture agreement did not allow for unilateral withdrawal in the manner that Mrs. King sought to do, and that she was bound by its terms. Now, at first instance, it was held that the developer acted in breach of sections 10(1) and 35 of the Real Estate Dealers and Developers Act when, by the joint venture agreement, it sought to engage in real estate business without the requisite license. Further, when the joint venture agreement was read in its entirety, it was unclear in respect of essential matters, thus rendering it void for uncertainty. In arriving at her conclusion, Justice Tai reviewed various provisions of the Act, that's the Real Estate Dealers and Developers Act, and delved into the joint venture agreement entered into between the parties. Now, as a part of her review of the legislation as well as the terms of the joint venture agreement, she made reference to certain legal issues and made these points. She referred firstly to one of the main contract textbooks, which is called Chitty on Contracts. and referred to the paragraph which says, paragraph 1608, contracts may be illegal when entered into because they cannot be performed in accordance with their terms without the commission of an illegal act. Thus, the contract may involve a breach of the criminal law, statutory or otherwise. Or alternatively, it may be a statutory requirement that the parties to the transaction possess a license, and where they do not, the contract will be illegal as formed. The implications of this lack of clarity and certainty were addressed in the Privy Council judgment of Western Broadcasting Services against Edward Siaga, which is a 2007 case. In that case, the issue of comprehensiveness of a settlement agreement was considered. Their lordships indicated that, and this is a quote from that case, it is trite law, so something that is known, that although parties may reach agreement on essential matters of principle, if important points are left unsettled, their agreement will be incomplete. Again, treaty on contracts indicates that in some cases, it can properly be said that the parties have reached an enforceable agreement on part of the matters in issue, leaving the rest to be determined by further agreement or the process of litigation. In others, the remaining details can be supplied by the operation of law or by invoking the standard of reasonableness. This brings to the fore that contractual terms must be certain. If a contract is vague or uncertain, it will not be binding. The learned editors of Treaty on Contracts went further to state that in determining whether a contractual term is certain requires the court to engage in a balancing exercise. The court cannot take too strict an approach, which may result in terms being struck down as vague when businessmen intend the term to be binding. The court must therefore have regard to whether A, a term that appears to be vague is governed by custom and trade usage, B, the vague term is reasonable, C, the agreement addresses which parties should resolve uncertainties, and D, an apparently meaningless phrase can still be effected and make efforts to give meaning to it. It is acceptable in some instances to have terms that are to be determined by further agreement. One such instance was in the case of Tomlin against Standard Telephones and Cables Limited, in which Sir Gordon Wilmot found that during negotiations, it is permissible to agree on one aspect while leaving another aspect for further negotiation. Now, these are some of the things that were taken into consideration when Justice Tai had to decide the case of Karif against Valreen King. On appeal, it was held by a majority, with Edwards, Justice of Appeal, dissenting in part, that Justice Tai had been correct in finding that the contract was illegal, as its terms contemplated the developer conducting certain activities as a real estate dealer for which a license under Section 10 of the Act would have been required, and the developer had no such license at the time of entering into the agreement. In relation to the second point, the unanimous position of the Court of Appeal upheld the submissions that the agreement lacked certainty in various material respects, which made it unenforceable. In his dissenting judgment, Edwards J.A. found that although the developer had not yet obtained the license at the time the joint venture was entered into, it had not yet engaged in any of the activities which necessitated having the license pursuant to Section 10. The developer was registered under Section 35, but the construction of the development had not yet commenced. It's important to note, therefore, that the case turned not on what could be referred to as general principles of contract law. My apologies. It's important to note, therefore, that the case turned on what could be referred to as general principles of contract law. Karif had sought specific performance of the agreement. However, the court would not support what it deemed to be an illegal contract between the JV partners. In recent times, there have been a number of matters in which the courts have been asked to intervene to protect the rights of citizens in respect of real estate developments being undertaken. Some of these cases have resulted in regulatory bodies being scolded by the courts for the ways for the way in which they have acted or failed to act in carrying out their regulatory functions. Many of these cases resulted from actions being brought by owners of land who were not party to the joint venture, but were persons who were entitled to the benefits of certain restrictive covenants, and which covenants were breached during the implementation of the development. Many of you might have heard on the news, just I believe it was earlier this month, arising from complaints made by, I think, a person described as a concerned citizen regarding the role of public officers in the implementation of a residential development. The Integrity Commission tabled a report in Parliament regarding its investigations into the circumstances in which a developer and two owners of a parcel of land entered into a joint venture agreement for the construction of an apartment complex, but seemingly did not conform to the approvals granted by the regulatory authorities for the implementation of the development. It remains to be seen what the results of those investigations will be and whether any aspects of the matter will be brought before the court. While it is clear that the means by which persons affected by improper real estate development may seek redress varies, it is also evident that each case will be determined on its own merits. The courts have the purview to review contracts, review the approval process, and to determine whether any rights or entitlements have been infringed. Hence, the need to have a properly drafted joint venture agreement and for the parties to be aware of their respective roles thereunder. Typically, joint ventures entered into in the context of real estate developments involve a developer entering into an arrangement with a landowner to construct townhouses or apartments on the landowner's land, in exchange for which the landowner will be given a unit or units in the development on completion. The arrangement may also involve the payment of money outright at the beginning of the contract, during the course of the joint venture, or upon completion. As with any contract which is being entered into, the parties should ensure that the terms are clear, certain, and capable of being carried out legally. So, what should be done? In seeking to implement a real estate development, whether it is being undertaken by two parties based on a joint venture or by a single entity, the parties must be aware of the legal requirements as well as the financial and operational considerations. It is always recommended that advice is sought from professionals in the relevant spheres when structuring a joint venture. Some of the main considerations are: what is the scope of the joint venture and what are its objectives? The scope and objectives of the joint venture should be clearly outlined, and what the parties hope to achieve from it should be clearly identified. Market research or analysis should also be conducted to ensure that the objectives are attainable. Landowners are often wooed by the prospects of receiving a unit or a number of units in the proposed development, but sometimes haven't considered whether the venture is actually viable. In the context of a real estate development, I dare say that one of the main objectives is to ensure that the development is soundly and properly constructed, completed on schedule, and the units sold for the price contemplated without many cost overruns, thereby hopefully maximizing profits. Another consideration is who you should enter a joint venture with. It is likely that for a developer, one of the determining factors as to who to enter the joint venture with will be based on the land which he has identified as being ideal or suitable for implementing the development. Even if this is so, and that is how the joint venture partner is initially identified, it is advisable that due diligence is conducted in relation to the prospective partner. Are there any encumbrances or issues which could inhibit the successful development of the land? From the landowner's perspective, he or she may want to ensure that the developer is one who is reputable, conducts business appropriately, for example, by having a reputation for adhering to relevant legislation and regulatory requirements, and perhaps has a history of successful projects. Another consideration is the structure of the JV itself. So, what structure will the JV have? For instance, will the parties form a company which will be responsible for implementing the development and in which they will each have shares, based on the project to be implemented, or will the parties take decisions jointly in implementing the project? What about the liability of the parties? Is it that they will have equal liability, or will one party be indemnified by the other in respect of certain risks? Who will have day-to-day oversight of the project? How will decisions be made? What happens in the event of disputes? All of these considerations go into the structure of the JV, and they must be contemplated before embarking on a JV. Financing of the joint venture is also one of the main considerations. How is it to be financed? In the context where a developer and landowner enter into an agreement, the norm is that the landowner puts up their property as their part of the capital or the equity. The developer may introduce cash as their portion, and then there may be financing, for example, construction financing that is undertaken in order to be able to complete the project. This usually has a smaller initial capital outflow or outlay, but it does still require consideration as to how the project will be completed. Considerations regarding financing should also contemplate how the profits or losses will be shared and what should occur if additional financing is required and if the development cannot be completed. Will there be an exit strategy? There may be circumstances which arise which require a joint venture partner to exit the JV or to be replaced by someone else. So, for example, what should happen if one or more of the parties dies during the course of the joint venture? This is especially so in circumstances where a separate entity or a company has not been formed. In a situation where a separate legal entity is not created to implement the JV, it may mean that the executors or administrators of the deceased landowner's estate will have to become involved. This could have dire consequences for adherence to established timelines. Other factors to be considered include what results in completion of the JV and what is to be put in place for its termination. Ordinarily, a joint venture is for whether a specific period or a specific purpose. So usually, once that purpose has been met, it would be said to be complete. Termination for other reasons, such as a material change in the party's circumstances, which makes him or her no longer desirous of completing the JV, therefore should also be considered. Regardless of the structure which has been decided upon for the JV, a joint venture agreement which sets out the parties' responsibilities, the interests of each party, profit and loss considerations, the governance structure, legal and tax obligations, and methods of dispute resolution, among other important terms, should be prepared for execution by the parties. Additionally, once the joint venture is implemented, there should be consistent monitoring to ensure that the development is progressing as it should. One of the biggest hindrances to the successful completion of developments is the lack of proper project management. This can result in delays as well as unnecessary cost overruns, which can significantly impact the development and prevent it from being successful. Without proper management, deadlines or timelines are likely to be missed, and what would otherwise be a smooth process may become frustrating and may lead to the failure of the joint venture. This is especially so in a context where financing, in particular construction financing, which is generally more expensive than ordinary financing, has been obtained and significant amount of interest accrue and have to be paid in order for the development to be completed. In our context, ensuring that construction occurs in keeping with the relevant approvals which have been obtained for the project will also be a major consideration for the joint venture success. So, in concluding, maybe the legislature, in its wisdom, will decide that it is time to make legislation regarding joint ventures so that there can be clear guidance as to how joint ventures should operate in our local context rather than leaving it up solely to the parties to decide. Until then, it is important for all parties to a joint venture participating in the implementation of a development to recognize that despite the terms of the joint venture which they enter into, the legislative and regulatory requirements governing the implementation of developments must be adhered to. The recently tabled report of the Integrity Commission into the development, which is now under great public scrutiny, highlights this quite clearly. As we have seen, the issues which arise may not necessarily be as a result of the joint venture itself, but rather may occur as a result of the circumstances which ensue in the implementation of the JV. The courts have made it clear that they will intervene if it is appropriate to do so, regardless of whether the issue arises from the breach of a restrictive covenant, the lack of adherence to regulatory or legislative requirements, or just the general operation of law. So one of the first things one should do when contemplating entering into a JV is to obtain legal advice. This is not just to generate work for attorneys, but it is to reduce the likelihood of the parties running afoul of the law by identifying the scope of the joint venture, the roles, responsibilities, and expectations of the parties, and ensuring that the parties understand their obligations also. Thank you very much.
Thank you very much, Lishan, for that very illuminating dissertation. I'm sure that when many people are entering the joint venture agreements, many are neophytes in this thing because they own a parcel of land or whatever, and are just ignorant of the pitfalls that can occur when the joint venture agreement is being implemented or fails to be implemented. Thank you very much indeed. I'm sure it has awakened the feelings of the audience of the necessity to pay attention to these details and the various issues which arise. We must now take a commercial break, and after we come back, Ishan will be joined by Mr. Alton Morgan and Mr. Norman Minot for the Q&A session. Thank you very much indeed, and on to the commercials.
Solutions, support, service, security. DG View Security. See what you've been missing.
Smart AI video analytics with active detection for humans and vehicles, line cross detection, license plate recognition, face recognition, and specialized cameras. Full service providers in surveillance systems, access control, solar lighting, alarm, and smart home systems. Visit dgviewsecurity.com or call 876-906-6528 for more information.
For almost 40 years, the JDA Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The JDA Group of companies, creating homes that people enjoy.
JPS. I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket, and stop it. Light up the path so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the path so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it's done. Every night, every day. Bringing light to everyone.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
Welcome back all. We're now approaching the time when we have the Q&A session based on the presentation done by Lishan. And we certainly would like to welcome our panelists Mr. Alton Morgan and Mr. Norman Minot. Alton, of course, he brings to the table about over 44 years of legal practice in the field of real estate. He has served the industry in many capacities, including the National Land Agency Advisory Board, Jamaica Chamber of Commerce Legislation and Regulations Committee, and the Land Divestment Board. Additionally, he is the legal advisor to the Jamaica Developers Association and as a practicing attorney, represented several well-known long-standing premium property developers. He has been a member of this Jamaica Developers Association for over 20 years. We welcome also Mr. Norman Minot. Norman is a consultant attorney with the law firm of Myers, Fletcher & Gordon, with which he has been associated since 1977. He has established himself as a leading expert in the area of residential, commercial, and resort development. He has also had the distinction of having consulted for the Jamaican Senate, the Registrar of Titles, on key amendments of local housing and property laws. In the public sector, he has served as chairman of the Municipal Services Commission, as well as the Parish Council Services Commission, among other things. We welcome both Norman and Alton, and it's a privilege to have you both to have your perspectives on the subject of joint venture agreements. Over to you. I see that there was a Q&A. No, I think on the, what are some of the tax considerations, says Christina Brown, that impact the choice of structure of the joint venture or the joint venture in total? Good question. Who wants to go first on that one?
Alton, is that you?
I'm thinking it through. There are a host of factors that would affect the structure of the joint venture and consequently the tax considerations. The typical approach which I use is to have specific contracts which involve an option to purchase and then the actual sale of the land to be developed and so on. But I think the common joint venture approach to real estate development is to have the owner of the land put the title in the name of a special purpose vehicle, a company created for the purposes of carrying out the development. And in those circumstances, you're going to have transfer tax liability of 2% of the value of the land. And then you're going to have subsequent transfer tax liability when the development is effected and the units are being sold. If there are commercial units, there's no rebate on the tax. If there are residential units, apartments, then yes, apartments and townhouses, yes, you will get a rebate. So it all depends upon the type of development and how it is structured. That would dictate what are the tax considerations.
Yes, it's very important. The structure is very important because you get very untidy when you don't have a special purpose vehicle and you have 2 or 3 or more parties to this joint venture agreement, and trying to work out the tax implications for each party is going to be quite complicated and quite untidy. So I agree with you, a special purpose vehicle is perhaps the way to go. Norman, do you have any comments on that?
Yeah, I agree, but I would say we have to be careful with the one shoe fits all.
Yeah.
Point. The fact is that I think we should look at each case on its own merits. All developments are different, one from the other, and it really depends on what we feel, what we can recommend to the client to be appropriate in the circumstances. Sometimes that varies with who the parties are, and all sorts of things. The financing, where is it going to come from, may affect that too. simpler may work. Sometimes, in fact, I would say most of the time, but there are times when more complex arrangements are entirely appropriate. So it's difficult to give an answer which is, which applies to all situations. The big takeaway there, I would say, is that you really do need competent, you, the developer, and the landowner really need competent legal advice before entering into a joint venture agreement. As Lisanne has pointed out, it's a minefield. It's an area where you can get yourself, all the people involved can get yourself into an enormous amount of trouble on rapid.
Absolutely.
It is not an area for amateurs. It's not an area for people who believe that they are lawyers and they can handle this complex area entirely on their own. If you doubt me, read the Karif case and look at the lessons that were learned by some of the parties involved in there.
Yeah. You have touched on one of the next questions, the possible roles of financial institutions in housing development. You lightly touched on it, but that's another minefield in itself, because that's going to require all sorts of hoops to be jumped through.
Yeah, and our initial speaker touched on that as well. I think he quite rightly pointed out that we really should be looking at the possibility of capital market type financing for developments of all sorts, and there is some of that taking place. You will know, but that in itself is a minefield as well.
Yeah, sure.
And there is something that has been mentioned thus far as well, that there are provisions in the Real Estate Dealers and Developers Act that are entirely relevant if a mortgage is in that sort of capital market type financing transaction is entered into by the developer with a mortgage institution, with an institution, the institution to whom the mortgage is granted, who is not what is defined in the Act as an authorized financial institution. But that's a whole, we could have a seminar entirely on that alone, but it's a big issue.
Yeah. Excellent. Another question. What happens when a development fails? How are the JV partners and any financiers affected? Alton,
wow. I tell my clients who come to me about joint venture agreements that they're contemplating marriage. It's just that it's going to be a business marriage, meaning it's going to last for a specific duration to achieve a specific purpose. But it's no less complex, and the consequences, if it doesn't work out, can be even far more serious than any benefits they would hope to derive. The structure of joint venture agreements must contemplate what if it goes wrong. I had to deal with a very unfortunate situation recently where the persons had entered into a joint venture agreement without proper legal advice, a mature couple. One of them suffered a medical episode which rendered them into incapacity. And it meant, therefore, that the agreement couldn't proceed unless a court order was obtained appointing a guardian for that person in the joint venture arrangement. And it, of course, was going to cause the whole thing to collapse. So we have to bear in mind that anything can happen which could upset the intent of the joint venture agreement. We mustn't assume that everything will work smoothly. persons die, but incapacity is the equivalent of actual physical death for business purposes. And all of that has to be contemplated as well. One of the unfortunate features of joint venture agreements, which aren't properly crafted, is the transferring of the property from the original landowner to the other joint venture partner. And it turns out that it's not so simple, because even where the other joint venture partner takes the title and then charges it to finance the development, there can be an issue of whether or not the original landowner as a joint venture partner is an unpaid purchaser, is an unpaid vendor who has a vendor's lien that can rank in priority to the subsequent financing for the venture. So it, as Norman has said, can be a minefield. And when the joint venture fails for whatever reason, you have to look carefully at all the factors to see who needs to be protected, and then chart a course forward to have it resolved. Invariably, it may lead to arbitration rather than litigation in the courts, because in arbitration, the parties can agree on certain elements, whereas litigation in the courts, you put the joint venture agreement up for examination as to whether it's good or bad. And if the court says it's bad, as happened in the Karif versus King case, then you have nothing to work with.
Afif, also, I think we should remember in this, the Real Estate Dealers Act, the Real Estate Board under the Real Estate Dealers and Developers Act, that when things head south, invariably the Real Estate Board certainly ought to be involved, because all joint ventures should involve a developer who is registered under Section 35 of the Real Estate Dealers and Developers Act. And in the event that there are contracts with purchasers, especially if they are prepayment contracts, there are after provisions under that act that are relevant. And that act also answers part of your question, which speaks to the ranking of priorities of the various mortgagees, including the board itself, in the event that there's a prepayment contract, where a statutory charge is automatically created. And so the real estate board becomes a major actor, a major player in the whole equation of how to unravel or solve the problem of a development that has gone south.
And if I can interject, what I'd say is that that's why it's so important for the scope and everything to be looked at from the very beginning. You do have clients who have land and significant amounts of land, and they're approached by, say, a developer to say, oh, I can build a number of units, and in the end, you'll get X amount of money, but they haven't seen any documentation. They have no idea as to what the cost of implementing the development is. They don't know what the market is like as to whether or not there are persons who want to purchase the houses, and they actually don't want to be involved in the day-to-day operation of the development. Things like that have to be considered, because that is what is to guide the type of agreement that will be entered into. You can't just sign any old thing and then decide afterwards, oh, but this is not really what I wanted, or this is not what I expected or intended, because it may have very significant consequences. In a situation where a development is undertaken, construction is ongoing, but financing runs out. If the parties are unable to obtain additional financing, you may have a stalled project where the landowner doesn't even have their land and there's no money to be obtained because the units are not in a position to be sold. So these are some of the things that have to be considered, and prior to the execution of the joint venture agreement. When it is executed, they then have to look at how is it being implemented and constantly monitor to make sure that it's being done properly.
Yeah, I totally agree, and that leads into the next question that I see here, which is quite a complex one. It says, I know the panel discussion is on joint ventures. However, could you say what is the best approach to take from the perspective of a financial institution when a borrower decides to create a special purpose vehicle for real estate development and then intends to transfer his mortgage residential property to the SPV, subject to the mortgage? How should the financial institution treat with such a request? I'm not sure that we either have the time or the expertise at this. Well, we certainly have the expertise, but I certainly think that before you get into that sort of complication, please get competent legal advice on how these things work and how to negotiate with your financial institution on what they want to be done and what you are comfortable with in circumstances such as this. We have a question from Cruz Brooks. What is the significance of a power of attorney when considering a joint venture agreement? Is that document sufficient to execute a JV?
This is one I think you looked at. Muted.
So,
sorry,
the power of attorney is simply one of the documents that would be adjunct to the joint venture agreement. I'm assuming they're speaking to the power of attorney that would be provided by the landowner to the other joint venture partner in order to fulfill the purposes of the joint venture. In practice, we use special powers of attorney that would allow the other joint venture partner to do things like apply for development approvals, building approval, subdivision approval, apply to have covenants modified, apply to secure financing, etc. The terms of the power of attorney are then very, very specific, and its duration is also limited to the time within which the specific objectives are to be achieved. It's not recommended to have a general power of attorney in use under a joint venture agreement. It's recommended that if there is a power of attorney, it must contain a ratification clause to say that anything done by the holder of the power must be ratified by the grantor of the power. It's a complicated legal document and it needs proper legal advice.
I agree with you, Alton. And what happens is that the general public, in many cases, tends to overrate the effectiveness of a power of attorney. I mean, what happens if the donor of the power dies? What happens if the donor of the power becomes mentally incapacitated? Those things will sever, or it will make the power of attorney non-effective unless it's one of those powers of attorney under the Conveyancing Act that is made with consideration. And all that type of advice has to be given. So I would urge anybody who is dealing with powers of attorney to be very, very, very cautious as to how they approach it. That in itself is the perennial minefield that could cause all sorts of problems. Another question, Don. Do you know of any instances where a joint venture failing in Jamaica, which involved financing from a financial institution? Do you know of any instances of a JV failing in Jamaica, which involved financing from a financial institution? How was the treatment of the settlement?
That was the Privy Council decision. The case involving what was then Capital and Credit Merchant Bank, the Mountain Valley Kess construction, and the Mountain Valley development, which failed. And the Privy Council found, in support of the Court of Appeal, that the real estate board ranked equally as a chargee along with the financial institution for the recovery of the monies which had been paid by the prospective purchasers. So there's judicial authority on how it should be dealt with in those circumstances.
Yeah. Any comment on that from anybody else? I think that's
no, not really.
That's adequate in itself, unless anybody else has any anything to add. Next question is, can owners of land be liable in instances where the approvals are breached by the developers, since owners just supplied the land under a joint venture? Go ahead. I don't know.
Well, what I'd say is that
it's a joint venture. You may very well be totally liable. You may very well have a lot of liability in that.
Right, because depending on the terms of the joint venture,
Absolutely.
just simply providing the land is not the norm. So that's why the terms are so important. And the unfortunate thing is that if there is a breach, the end result may be that the land is no longer available as it previously was.
Yeah. Next question is, can the owners of land be held liable in instances where the approvals are breached by the developers? Since owners simple, that was the same. It's the same type of question. And I think the answer was, we have Ricardo Ming asking, what is the best or recommended mechanism to determine the share distribution of the completed units between the parties of the joint venture? That is really dependent upon the agreement of the parties, and everybody must look at, it's going to be based on negotiation and cost and money and interest and all that type of thing.
I agree, Afif. But to get back to some of the earlier questions, this Karif case is really important, and I'm glad that Lisa spent so much time.
Yes.
Explaining it, dissecting it, because I think it is going to have, or it probably already has had, a significant effect on the whole business of development in Jamaica, especially joint venture development. My own suspicion is that, given what has been decided in that case, there may be a significant number of the joint ventures out there that, if they were tested, may be found wanting. I'm talking about in real estate developments, where the owner puts up the landowner puts up the land, and there is a developer, sometimes very competent, with the ability to bring in the capital and the expertise to produce a successful development. But where the joint venture agreement is akin to what was in the Karif case, let us say that even if it's not void for uncertainty, where the wording of that agreement was really unfortunate. But the landowner puts up the land, and the developer says, look, I have the expertise. Let's let's pool our resources. It's efficient. It makes sense. I can get the financing for you, and we will share the profits, and we'll all live happily ever after. With that case has pointed out that, given Section 35, if we take it in chronological, take it in terms of what should be done first. If the developer is not registered as a developer under Section 35 of the Real Estate Dealers and Developers Act, there could be a problem. Then, if the developer is not registered pursuant to Section 10, as defined in Section 3 of the Real Estate Dealers and Developers Act, then and registered, that is, as a dealer in the circumstances that I have described, then you may well have what is an illegal contract, which is unenforceable, and the thing falls apart, possibly at a time when there are already purchasers, some construction done already, and possibly purchasers' interests affected. It's a very serious situation, that I think needs to be looked at by the regulators. Why do I say that? Because the truth is that the typical developer wouldn't have a dealer's license. My understanding of the way the Real Estate Dealers and Developers Act is structured, the dealer's license is really was always intended and to apply to a sales force, to somebody who commands, who controls contracts with salesmen, not developers. And therefore, although I will agree the way the act is worded, I can't disagree with the finding in the Carib case that if you organize yourself in such a way as to get caught by the provisions of sections 10 and 3, then you may well need a dealer's license. But I repeat, I don't think the act ever contemplated this. For those of you who don't know, it takes 4 to 5 years to qualify for a dealer's license. And most of the training is how to administer sales and salespersons. It really was never intended, nor I believe, nor is it really designed to deal with regulating developers. So I think that the industry has a situation in its hands. I believe it's something that requires urgent attention. I have a feeling, I have reason to believe that the real estate board is aware of the situation. Let me just put it that way. And I really hope that it is going to be addressed soon.
I can come in here now, man. What the judgment is in effect saying is that the developer who elects to do direct marketing of the units that are proposed to be developed becomes a dealer. And if he's not licensed as such, then he's in breach of the act, because it's one thing to be approved as a developer. It's another thing to engage in the sale of the units as a dealer. And in effect, that practice seems to have crept in, where you will have a developer, but they're not a dealer. And they're actively going about selling the units, taking commission on the sales, not treating with the monies that have been paid, being put in escrow and so on, and generally flaunting the terms of the statute. So the judgment is pointing to the fact that until the developer brings himself under the umbrella of the statute for the purposes of selling the units, then he's acting illegally.
Interesting.
Right, and if I might just add in that regard, it's in a context where the developer is selling the units on behalf of someone else. So that's where, in the context of the JV, where you have the landowner retaining ownership of the property, which is then subdivided or stratified, and then that is the person who is responsible for selling as the vendor, so to speak, and the developer is the one who is arranging the sales of those units. They're in breach if they don't have that license.
It may even be more than just the sales, because where the developer is offering expertise in the construction, right? Then there is that. Where the developer is providing expertise in bringing financing to the table, there's that too. So,
yeah. I think we can take our last question for this Q&A session, and I see Dayton has his hand up, and I think that's the last question we'll take in this session. Dayton, would you like to proceed?
Well, just to ask the question, because we're a developer, I always thought a developer selling his own product did not require a dealer's license.
Yeah, that's correct.
Okay, so you only in the case of a joint venture where he's setting up some product that's other than his own,
Yes,
what
because he would be acting
ruling
as
would
an
apply to.
agent of the landowner.
Right. Okay. All right.
Thanks very much, all. We have to end this now. What a very spirited discussion. It has been absolutely interesting and enthralling. But we are at that juncture where we need to take a commercial break. So we'll come back shortly.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
For almost 40 years, the JDA Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The JDA Group of companies, creating homes that people enjoy.
Solutions, support, service, security. DGView Security. See what you've been missing.
Smart AI video analytics with active detection for humans and vehicles, line cross detection, license plate recognition, face recognition, and specialized cameras. Full service providers in surveillance systems, access control, solar lighting, alarm, and smart home systems. Visit dgviewsecurity.com or call 876-906-6528 for more information.
I light up the streets, I light up the beat, I light up the place where we meet and greet. I forward the thing, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, forward the music in the worship. Light up the moments that matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Forward the socket, now stop it. Light up the part so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the part so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it done. Every night, every day. Bringing light to everyone.
Welcome back, everybody, to the webinar, and look forward to the next presentation, which discusses the important role of quantity surveyors, has been pointed out before in today's presentations. The role of a quantity surveyor is very, very important to the development of any development. And in this vein, I'd like to welcome Mr. Ryan Edwards, who is president of the Jamaica Institute of Quantity Surveyors. Mr. Edwards comes to us with over 17 years of experience as a quantity surveyor in both the public and private sectors, and having held various offices in the Institute, rising to the position of president for 2022 to 2023. He also holds the position of chairman of the Construction Industry Council, and he finds time, I don't know how he does, to find time to be active in community growth and sporting activities. So it is now my pleasure to introduce Mr. Ryan Edwards to address us on the role of quantity surveyors. Mr. Edwards, Ryan, are you there?
Good day, everyone, and welcome to my presentation. I feel honored and privileged to be involved in this webinar. It is my pleasure to put together this presentation for you, and I hope that upon completion of this presentation, persons will have a deeper appreciation for quant surveyors and their team, and having a better understanding of the qualities of a quantity surveyor. Today, I'm tasked with the responsibility of presenting on the topic, the role of quant surveyors in real estate development. And as my introduction, my name is Ryan Edwards, and yes, I'm a professional quantity surveyor, and yes, I am the current president of the Jamaican Institute of Quantity Surveyors, and the chairman of the CIC, and also managing quantity surveyor for a vision project. Today, my presentation will be on, did I share my screen? Okay. I'm hoping that everyone is seeing my screen. So today, my presentation will be on the role of quantity surveyors in real estate development. And I want to my presentation will focus on quant surveying, a brief history of quant surveying, including Jamaica, quant surveying head, who is a quant surveyor, and the role and responsibility of a quant surveyor and professional quantity surveyors. Quant surveying. Quantity surveying play a critical role in ensuring that a project is constructed efficiently while maintaining a tight watch on a project's finances and contractual relationship between the different parties to the contract, making sure everything is accurate and controlled effectively throughout the life of the project. Consequently, it is critical to have an appreciation of how surveying can affect your project and its overall cost. I want to just share with you guys the Bible is taken from Luke 13, 28 to 30. We're using the NIV version. And verse 28 says, suppose one of you wants to build a tower, won't you first sit down and estimate the cost to see if you have enough money to complete it? For if you lay the foundation and are not able to finish it, everyone who see it will ridicule you, saying, this person began to build and wasn't able to finish. That, in essence, is how quant surveying comes in a construction project. Now, brief history of quant surveying. It is widely accepted that quant surveying existed during the period of the construction of the pyramids and temples of ancient Egypt. At that time, they were referred to as measurers of royal works. In Jamaica, the main thrust of professional quant surveying in Jamaica was in 1949. As the construction industry in Jamaica expanded in the late 50s, so did the need for a quant surveying profession. It is therefore timely when the Jamaican Institute of Quant Surveyors, then the Jamaica Society of Quant Surveyors, was founded in 1959 with all its founding members embracing the skills of quantity surveying. How can quant surveying help? One, it helps to avoid risk and dispute. Risks are a commonplace on construction projects. It is important to identify risk and generate plans to safeguard projects against these possible situations. Quantity surveying allows you to generate precise cash flow projections. These are essential to assist you to anticipate any potential risk associated with unreliable estimates and even overspending, ultimately giving you the opportunity to plan and adjust your budget ahead of time. It also helps to identify saving opportunities. Quantity surveyors utilize their unique blend of different professions, such as accounting, architecture, and/or engineering to find ways that are cost-saving to a project. This includes, but not limited to, a wide range assessment of the variables for the project cost, step-by-step cost reporting, evaluate project expenses, which should result in finding areas of the project budget that can be tweaked to reduce costs, such as human resources, material substitute, or even alternative construction technology. It's also helped by enhancing project efficiencies. Quant surveying ensures that your construction project is completed as efficiently as possible. This is so because the potential cost of a project can be anticipated strategically planned and make decisions regarding the project. There is an opportunity to track costs where you will be informed of the expenses if you continue along a particular path, allowing you to make adjustments in order to save money, time, and resources. Quantity survey, who's a quant surveyor? A quantity surveyor are the trained members of the construction professional team who are responsible for the financial management of the construction project. They are also the construction industry professionals with expert knowledge on construction contracts. A quantity surveyor is sometimes referred to as a construction cost consultant, a cost estimator, building economist, construction accountant, or contractual and procurement specialist. A quantity surveyor will typically need to work alongside a client to establish their requirement, undertake feasibility study to ensure proposal will work, estimate material quantities, cost, labor, and time, prepare tender and contract documents. This can include bills of quantity with the client and the architect engineer, perform risk and value management and cost control during the project, undertake cost analysis for repair and maintenance work, negotiate contracts and work schedule, assign works to subcontractors overseeing their work at all stages, value completed work and arranging payment, ensure project meet legal and quality standards, make sure clients get value for money on the project, and continually analyze outcomes and write budget reports and advise on contractual claims and dispute. When should a quant surveyor be engaged on a project? A quant surveyor should be first on and last off when the professional team is being developed. Ideally, the quantity surveyor should engage around the same time as the architect and our engineer is engaged. This will ensure the project cost and the project can be afforded, and that the project can be afforded before the submission of building plans. It doesn't necessarily mean any commitment at this stage, but it is better to ask for advice earlier rather than find it is too late. Often people start off their project without quant surveying advice, and it can make the project significantly harder. Too often, a quantity surveyor is only brought in when there's a crisis. If a quant surveyor is engaged early, then the crisis may be avoided altogether. When a quant surveyor is engaged on a project, the client will be getting a professional and expert cost controller who understand the ins and outs of the construction industry, the market, and potential cost pitfalls to avoid. And I just want to put in an example of when a quant surveyor should be engaged. And there's a story about a developer who, on advice of a contractor, came to a quant surveyor for him to prepare a bill of quantities, because the bill of quantities was needed for the bank, for the entire loan purpose. But when the developer came to the quant surveyor, and the quant surveyor did the ROM and did the budget, at that point, the developer realized that it was not as profitable as he was led to believe. And at that point, after it was approved by the parish council, approved by NEPA and other agencies, you find that the developer had to go redesign the project and resubmit it just so that the project can be profitable. Right. Roles and responsibility of a quant surveyor. At the start of any project, a quant surveyor will study drawings and specification around a new building, This will normally be provided by the architects or engineers and often involve BIM, where data is used to produce a digital representation of an asset across its life cycle. This process enables you to calculate the quantity of materials required for the building. Additionally, this data will be used to provide early cost advice to budget and benchmark the project and to prepare life cycle cost plans. Conservator responsibilities are to focus on helping to estimate costs, material, labor, plant, associated costs, material quantities, and project timelines. A key part of their role will be to liaise with a range of other teams working on the project, helping it to stay on track within time and budget. Conservator role can be broken down in 3 areas: pre-construction stage, during construction stage, and post-construction stage. At the pre-construction stage, we have cost estimation and budgeting. The quantity surveyor examines the architect and engineer's plan, project specification, analyze site conditions, distinguishes the expenses involved, and then set a general assessed budget for each task in the project. This is an important responsibility that set the foundation for a successful construction project. Leveraging their expertise and knowledge of construction materials, labor rates, and the market condition, quantity surveyors provide detailed cost estimates. These estimates cover various elements such as material, labor, equipment, and overhead costs. Accurate cost estimation enables stakeholders to make informed decisions about project feasibility, securing financing, and plan budgets effectively. Then the design phase. In the design stage, the quantity surveyor involves the design team and suggests practical solutions for which the project can be completed within the project's allotted budget, which is called value engineering. A quantity surveyor will advise the design team on cost for each element included in the building and how it impacts the overall development cost. This is important, especially when dealing with maintenance of building and infrastructure such as sports stadium, tunnels, bridges, university, residential buildings, hospitals, and roads. Tendering stage. In this stage, the quantity surveyor advises on tendering and contractual plan, considering the client's needs and other data accessible from the designers. They also report on the client's liability and obligations such as insurances, bonds, taxes, and levies. The detailed tender document, including bills of quantities and technical specification that outline the project requirements. Also, final tender estimate is prepared by the quantity surveyor, which is shared with the client and project team. During this stage, quantity surveyors play a vital role in negotiating contracts and ensuring compliance with legal and regulatory requirements. They analyze the financial aspect of bids, assesses contractual terms and conditions, and help the client make informed decisions when selecting contractors or suppliers. They advise shortlisting bidders and looking into the tender financial standing and experiences. The quantity surveyor also advises on errors and negotiates offers, the final review of bid document and recommendation for the best tender preferred bidder. Effective management of the tendering and procurement processes ensure that the project progresses smoothly and within the established budget. Now go on to the construction stage. During the construction phase, the quantity surveyor monitors the project progress. They will continue to fulfill critical responsibility to ensure effective cost management and project control. Measurement and quantification of materials. During the construction stage, the quantity surveyor accurately measure and quantify materials required for the project. They assesses the construction drawings, specifications, and takeoff methodologies to determine the quantities of materials needed. By precisely quantifying material such as concrete, steels, blocks, and other components, quantity surveyors facilitate effective procurement, minimize waste, and control cost. An example of this is a quantity surveyor may assist in providing a bending schedule for reinforcement in a structure using the detailed drawings. And this information will assist in procuring the correct quantity of materials and ensure effective use of resources. Cost control and management. Quantity surveyor monitor projects expenses, track actual costs against the budget, and analyze any deviations. Quantity surveyors work closely with project teams to identify potential cost saving measures and implement strategies to control expenditures without compromising quality and/or safety. Additionally, quantity surveyor assesses variation and change order that may impact project costs. They evaluate the financial implication of proposed changes, negotiate with contractors, and advise on the financial consequences of approving or rejecting variations. By actively managing costs throughout the construction stage, quantity surveyors contribute to the financial success of the project. The quantity surveyor prepare valuation and recommendations for payment to contractors, subcontractors, and suppliers as per the agreement prerequisites. And then we go to the post-construction stage. In the post-construction stage, quantity surveyor play a pivotal role in finalizing project accounts and optimizing cost-saving strategies. In doing that, they do the final account settlement. One of the key responsibilities of a quantity surveyor is the post-construction stage, is the settlement of the final project's account. They review actual project costs, verify the quantities and measurements of material used, reconcile any discrepancies. Quantity surveyors ensure that all contractual obligations are fulfilled, including the payment to contractor, suppliers, and consultants. They also handle the assessment of variation and claims, facilitating fair and transparent resolution. By meticulously reviewing and finalizing project accounts, quantity surveyor contribute to the financial closure of the project, ensuring accuracy and transparency in all financial matters. Value engineering and cost-saving strategies. In the post-construction stage, quantity surveyors employ value engineering and cost-saving strategy. They analyze the project performance, assesses opportunity for improving efficiency and reducing costs, and provide recommendations to optimize future construction endeavors. By applying their expertise, quantity surveyors identify alternative materials, construction methods, or design modification that can result in cost saving without compromising quality. Professional quantity surveyors. Why is it important to use professional conservators? One, they get the job done within a shorter time. This is just due to the fact that professional conservators has done the same work over and over again. They can get the job done in a much shorter time. They do the right thing the first time. And again, this is because they have a vast experience, and so they will complete the task correctly at the first time. Better result over the long run. Professional conservator will put in place mechanisms to allow the project to flow smoothly throughout its lifespan. Your team stay focused on what they do best. Again, because they're professional conservators, they understand their roles and responsibility, which will now result in other members of the team, architect, engineer, developers, evaluators. Everybody could focus on their work and not necessarily watching over a professional conservator. They solve problem faster and know what problem to be solved. Any issue arise, professional conservator will know which clause and may provide resolution to the potential dispute. Okay, professional conserving, the Jamaican Institute of Conservators. The Jamaican Institute of Conservators, and this is because professional conservators in Jamaica are either members of the Jamaican Institute of Conservators, or some are RICS member. But as Jamaicans, and again, as president of the JIQS, I would advise that we look for members who have MJIQS at the end of their name, or FJIQS. So JIQS advances the interests of the profession of conserving to maintain the highest possible standard of professional ethics and practice, to encourage uniformity of practices and procedure, and foster public faith in and understanding of conserving and their work. It protects the public who are otherwise engaged in the services of unqualified persons who promote themselves as conservators, bearing in mind the level of education and training necessary to properly undertake the necessary roles. Avoid and minimize the adverse consequences which arise when payments recommendations are not made by professionals who can be held accountable should there be any shortcoming in the exercise of their roles. Ensure the maintenance of acceptable levels of professional conduct. Other duties of conservators include claim and dispute management, reinstatement cost assessment for insurance purposes, prepare valuation for insurance purposes, prepare and price schedules of dilapidations, prepare maintenance schedules and whole life costing, assist with litigation and arbitration processes, facilities management, life cycle cost analysis, prepare schedule of conditions, technical auditing, project management, and sitting as an arbitrator, adjudicator, etc. So in ending, the future of conserving. As construction projects become increasingly complex, the demand for skilled conservators continue to grow. The future of conserving lies in embracing digitalization, automation, and sustainable practices. Conservators will play a pivotal role in managing costs, optimizing resources, and ensuring the financial success of construction projects. They will advise clients on carbon emissions generated by their project and buildings, advise on property taxation, assist clients in securing fundings, help client initiate construction projects, and provide post-occupancy advice and offer life cycle cost advice. That's it for my presentation. Thank you very much, sir.
Thank you very much, Ryan. That was very interesting indeed and very detailed, and certainly pointed out the role of quantity surveyors. Thanks, and their contribution to the real estate development industry. It's now time for another commercial break, and afterwards we will have two distinguished panelists join us, Mr. Winston Josephs and Ms. Veronica Royal, in the Q&A session. And remember, please don't hesitate to ask your questions by either dealing with the Q&A icon or raising your hand if you want to speak to the presenters. Let's go to a commercial break now.
For almost 40 years, the GEON Group of companies have been developing plans, laying foundations, building hundreds of homes of distinction, creating exclusive and secure communities in which we live, play, and raise families. The GEON Group of companies, creating homes that people enjoy.
JPS. I light up the streets, I light up the beat, I light up the place where we meet and greet. Half of what they think, then we make life sweet. I light up the church where the pastor preach. Light up the good times in the service, power the music in the worship. Light up the moments we matter, light up the laughing and chatter. Light up the net and the rocket, light up the score so you know who got it. Power the socket, now stop it. Light up the part so you don't lose your way. Light up the field so you don't miss a play. Every night, every day. Light up the part so you don't lose your way. Every night, every day. Light up the field so you don't miss a play. Every night, every day. Light up the party from now till it's done. Every night, every day. Bringing light to everyone.
Solutions, support, service, security. DGView Security. See what you've been missing.
Smart AI video analytics with active detection for humans and vehicles, line cross detection, license plate recognition, face recognition, and specialized cameras. Full service providers in surveillance systems, access control, solar lighting, alarm, and smart home systems. Visit dgviewsecurity.com or call 876-906-6528 for more information.
Capture all the sweet moments in your own sweet home. Up to 100% financing from JN Bank will get you there. Get pre-approved now. JN Bank will help you find a way.
Welcome back, everybody. And we welcome our panelists at the stage of the game, who are Mr. Winston Josephs and Ms. Veronica Royal. Mr. Josephs is a chartered valuation surveyor with more than 26 years of experience in the business. He holds a Bachelor of Science degree in Estate Management and from the University of Reading in the UK, as well as, among other accolades, a diploma in Land Economy and Valuation from our own University of Technology. He's a member of the Association of Land Economy and Valuation Surveyors and a member of the Royal Institution of Valuation Surveyors. After serving with the National Land Agency from 1987, where he was involved in valuations for land acquisitions for Highway 2000 and part of the proposed Montego Bay bypass, he joined the Victoria Mutual Group as qualifying director designate for Victoria Mutual Property Services Limited. His experience includes valuation of residential, commercial, industrial, and leisure properties, as well as valuations for property tax purposes. Ms. Veronica Royal is no stranger to any of us. She's a decorated charter quantity surveyor with over 35 years experience both in Jamaica and internationally. She made history in 1988 as Jamaica's first female quantity surveyor to gain full membership in the Royal Institution of Chartered Surveyors in the United Kingdom, being promoted to fellowship of that institution in 1999, which is a title held by less than 20% of surveyors globally. She also holds the title of Fellow of the Jamaican Institute of Quantitative Surveyors. After gaining invaluable experience as a partner in the firm of Stoppy, Kearney Bloomfield, she now heads her own firm, Verco Limited, since 1999. Ladies and gentlemen, it gives me the greatest pleasure to welcome these two panelists. And please continue with your questions. We have a question that says, not mentioned in the key quantity surveyors roles, as QS valuation certificate is required by financial institutions to draw down on the construction loan, most times supported by a statement by the QS of the cost to complete the project. I'm not sure if that's a question or a statement, but yes, the QS certificates continue throughout the whole project and certifies, I think, payment to the developer from the mortgagee. Is that so? Or from the financier?
Yes, if I may come in. Yes, normally for construction loans, financial institutions usually require a QS report. And of note, Ryan said something earlier that is very important, that QS normally starts, it comes in at the start and also is the last after the project, right? Not his exact word, but normally the QS starts with the project and also ends with the project. So a QS report is normally required whenever you are getting any financial support from the mortgage institution. And VM in particular normally requires that kind of report from a professional quantity surveyor. And the reason for that is that it guides the process in terms of determining how much is required to complete the project. And of course, it is normally, the funding is normally, depending on the nature and the size of the project, is normally issued in tranches, you know. And of course, the QS is not just to prepare, as Ron stated, just to prepare the initial quantity surveying or the quantities, but you would also be engaged in the entire length of the process from start to finish. And from time to time, the bank will require a report from the QS in terms of the actual work that has been done, sometimes how much is supposed to be paid out, and the quality of the work that has been done, and so on. So yes, the QS report is very, very important for the financial institution that is providing the funds.
All right. Maybe a question that Veronica can answer. Traditionally, QS bill is only as a percentage of the total project, or can it be a fixed cost?
I think the person is talking about fees, but before we get there, I just want to point out the important role that the quantity surveyor plays in managing that budget. There's one thing to be reporting on what is happening, but a more important role is to help in prevent what will happen, especially when you have variations, when you have that scope creep happening, when you have that when you have delays, when you have so many things. There's so many risks with construction. So one of the things that quantity surveyors will try and do is making sure they validate, they indulge in managing that budget. And in Ryan's presentation, which I think value engineering was shown as a post-construction activity. I think that's probably some misplacement in the slide. But that occurs really during the process of construction. And so we work along with the team members in making sure that the budget that was established at the beginning, whether by the client or through that competitive bidding process or negotiation, that what happens in between, that everybody is kept on track. And if for any reason something go over, at least we sit as a team and see what can we do in order to bring back this particular project into budget. Sometimes some of the risk can't be avoided, and some of those costs that are likely to occur can't be avoided. And this is where it is very important that the client is informed early, because you will have financial institution being involved. A client will have his fixed liability, maybe selling a unit to persons, and that escalation is capped and so forth. So the role of the quantity surveyor in that value engineering and managing that budget is extremely critical. Onto the question now about fees. That is something that persons will decide along with whomever they contract to do their services. Usually the basis in terms of a percentage really give everybody, and lawyers do it, other professionals. It's really a gauge for you to know whether or not it's been reasonable or not reasonable. And sometimes with construction, it's very, very difficult at the outset when the designs are not yet finished. Persons haven't yet fully fleshed out their scope of work and so forth, but yet you want to engage a quantity surveyor or any other professional at that particular stage. It is very difficult at that stage sometimes to fix a price, because you really don't have all the data that is necessary for that price to fix, but at least you have agreed on a method of addressing that. You could agree to fix it at a particular stage when information become known, and you can have it fixed there. But there is always that process of agreement between the person who engage a professional and the professional as to the basis on which they will calculate their fees.
Thanks, Ronnie. Any comment from you, Ron? On mute. Yes, you're okay.
I mean, member Philip, Ms. Royal has said a lot and has covered almost everything. Just to add that when it comes to conservators approving valuations or being a part of a team, conservators are trained and have the highest ethical principles and standard that allow them to value our work and present that work, because especially if they're the one who are engaged in the project from inception, they will value the work done and make a presentation to the client, which will speak about how the contractor should be paid, or to the lending agency that will advise lending agency at the value of work completed to date, and if any other disbursement should be made for the project.
I see Veronica has her hand up. You want to say something, Veronica?
Yes, I want to also add, which Ryan had in his presentation, but delve a little more into procurement and the role that how you go about that process, as Stephanie had alluded to in her presentation, could really have a significant impact on what happens afterwards. There are sometimes clients would enter into an agreement with a contractor, which is really very loose. They didn't engage a quantity surveyor in that process. They didn't even engage an attorney either. They just, contractor provide them with a cost, and they said, yes, I want a 3-bedroom house, and they agree this cost. But within all of that, there are so many things that can go wrong. So you need to have a form of contract that is agreed. And as Stephanie had pointed out, that, there are standard form we have. There are others, sometimes based on the client situation. Maybe a bespoke form of contract is probably, a better option. For example, for some of my clients, they want to do design and build, or they want to even start the project before the drawings are completed. Now, there are so many options to have that done and to have a proper contract in place. Where you have situation like that and you don't have a standard form to guide you, sometimes this is where an attorney would come in order to help in drafting that particular contract, because there are other standard design build contracts out there, but we probably don't have. Another way that I sometimes see people wish to carry out their project when they don't have drawing is sometimes it could be cost plus, but with a target cap, because when you don't have that cap, this is where a whole heap of dispute can come about, because you didn't agree on a price at the outset. You agree on the basis, of course, on which that price is going to be calculated, but you did not cap it anyway. Sometimes they may decide, well, we want a shade, we want to agree the rates, and the project would be measured as we go along. It depends a whole lot on the quantity surveyor during that time, because you are dealing with several moving parts, and a client has a budget, and we need to respect that budget at all time. We need to ensure that information is passed to the client on a timely basis. Information is passed to the design team on a timely basis, because they may be designing because they like what is being designed, and they don't recognize or may have some idea of the cost, but they are not really tracking it in the same way that the quantity surveyor is tracking it. Sorry about that. I saw that my battery is running low, so I'm plugging in. Yes, okay, yeah. So I'm sorry about that. So I'm just really basically saying that aspect of the decision before you even start constructing is really very important. And as Ryan said, get the quantity surveyor involved very early. Don't wait until late. So many times when the dispute arises, somebody will come and will say that they need a quantity surveyor to help them here because the contractor says, or the developer said, whomever said, but when you look on their documentation, it wasn't properly put together, and the method by which they were to derive that cost that they said they agree on, there is no method there. So they end up into a big dispute over what is the cost and trying to settle it too late in the whole agreement process.
Yeah. Ryan, you wanted to say something?
Just to extend on what Ms. Royal said, especially when it comes to bringing the conservator early in the process, because one thing that we realize is the time saved by, and this is just for the job to commence.
Absolutely.
The time saved by bringing the conservator early, so yeah, the entire team can have that discussion about what is needed. Look at the design in terms of, one situation I saw was a builder, which happens very, very often. We realize that persons will get loan, they will go to a funding institution, And then they have this design because they're designing their dream house. And then when they come to the quant surveyor said, well, this is how much your dream house costs. But they really truly have a fraction of that cost.
Yeah.
And then the process is delayed because probably they have to do a redesign, or they have to do a different discussion with the bank and stuff like that. But then again, quant surveyors are trained to handle this situation and giving proper advice on if that situation happened, what would be the next step.
Veronica, you wanted to say something else?
Yes, I wanted to also add, which Ryan addressed in his presentation, but about risk management. And I Stephanie did speak about that too, because as a quantity surveyor, we also will identify certain risks and try to manage them or forewarn persons about the risk that they're exposing themselves to. And for example, I had a recent situation where the project overrun, but it didn't overrun because of the fault of the contractor. The insurance run out. Now, the contractor has not applied for extension of time. So you can see where the problem is going to arise here and some exposure. So on one hand, the contractor has not extended the insurance. It must be extended, which, as you alluded to before, where this has not been done by the contractor, then the employer has to step in to ensure that that project is insured. Now, who to pay is something one could decide after. But if there is no extension of time claim from that contractor, he is having that liability hanging over his head. Now, you don't want this to wait until 6 months later or sometime later to become a problem. So usually the quantity survey is there trying to identify some of these risks, trying to help the parties to manage them, trying to get them to understand what the contract says should happen to prevent some of these issues from becoming major issue. So, in addition to all of that, in terms of compliance on a number of other things, we, the quantity surveyor, are there to try and guide. And some clients, sometimes they don't have the necessary expertise within their team. And this is where they end up having some major problem. There's not that person with this skill as a professional quantity surveyor to help in guiding them through this particular process. But you need someone on the team who understand their group.
Yeah, you just disappeared. I don't know what happened to Veronica, but she disappeared. But she was making a very valid point. Is she back?
I don't see her.
No. All right. We just have to carry on. Then when she comes back, she comes back. I have a question on the Q&A icon. After listening to the presentation on the role of quantity surveyors, I'm now a little confused. Tell me, if I am building a residence, who should I rely on to manage the project? Is it the architect or the quantity surveyor?
That's a question. That's a question maybe for Ryan, but I want to give my input because I think both parties, both the architect,
Miss Royal
is coming back. So both the architect and the QS, they have roles to play in the construction process. Well, not only do they have role to play, but even the financial institution. So everybody is playing their little part in terms of managing the project. The financial institution is managing in terms of payout and getting feedback from the QS in terms of how much work has been done, the quality of the work, and so on. So everybody is playing a part. The architect, of course, is dealing with the more technical or structural issues. Is the building being constructed to the specification the size and the material and so on. And of course, Ryan, as the QS, we look at the cost and the material and that sort of thing. But Ryan, you can give your feedback on it.
Well, for me, the reality of it is who managed the process doesn't necessarily have to be a quantity surveyor nor an architect. We could look at engineer or project manager to manage the process. What you want to do is to find somebody who is competent in understanding how to manage processes. As a quantity surveyor, I may be biased, but I will say to you, once you find somebody who is competent enough, then you frankly get an overlap of knowledge base if you use a quantity surveyors who will know manage the process, but also understand the cost implications of each element of work. And so, we have to understand that a contract administrator, especially according to our standard form of contract in Jamaica, using the CIC contract standard form, then they speak to a contract admin. And a contract admin can be defined as anybody with the prerequisite knowledge, expertise, and training that is competent enough to manage the process. And so whoever the person is comfortable with, bear in mind that they are the designer, or the engineer, they are the designer of the project, and they are the one who have the expertise in accepting quality. And so, yeah, that have the advantage. But each person present their own value to the management of the process. A quant surveyor will look probably mainly on the costing and how the costing is being affected, and also look on quality and the management of processes, while an architect may look at just the aesthetics and how you follow what is designed. So there's no exact science to it. There's no exact one person who should be. All parties of the construction professional team, once they reach a level of competence, can manage the process.
Okay. Sorry about that. I just got my battery ended and I didn't realize that I didn't properly plug it in. I'm so sorry. But I want to also add to what Ryan says, that, an architect will have a fair idea of how much the project will cost, or even a client, because he may have benchmarked it against another project, and he may know that I want to bring in a project at X amount per square foot and all that high level, consideration. But the quantity surveyor can actually look on those drawings in order to accurately measure and price, give that client the assurance that that project can be brought into to completion at that cost. They also help in guiding the architects and the engineer during the design stage, because sometimes there are some early warning signs that the client's budget can't be accommodated within this particular design, or the choice of material and the costs and so forth. Also, in terms of space planning, the efficiency of the design, this I find also is a very important issue, because sometimes when the drawing arrives on your desk as a quantity surveyor, you realize that the building is so inefficient. Say, take for example, a developer is selling some apartments, or a commercial developer is renting some space or selling it. If a lot of the space is tied up in common areas that you cannot account for when you go to your client to rent or sell a space, you have some problem, and those are our cost drivers. So these are some of the things as a quantity surveyor. Looking at cost, you look on the design also, and you give the client and the design team accurate feedback and very timely feedback too, not waiting until when you reach a stage where you have tendered and the price is too much. Sometimes that happens because the quantity surveyor was not given that opportunity to look on the project, to be involved in that design process and to provide that feedback. So we're really basically saying that in terms of our role, it is really very important from the very outset, because sometimes it's something as even looking on the site from the beginning, where the site may be a lot of rocks, the topography of the site is very challenging and so forth. So when you look on that and what the client expressed in terms of their budget and so forth, we have the knowledge and the data, the cost data to sort of benchmark and give some fair guidance in terms of what to expect and how to try and mitigate some of these issues.
I think I see another question coming in on the Q&A. See. Thanks for that, says Dunstable Morgan. But what I really want to know is which one party should I hold accountable as the project manager for delivery of the project?
The project, if it's the project itself, it might be the contractor, the person who is actually doing the work.
That's correct.
Not necessarily the quantity surveyor or the architect. Because the architect could have, you could probably say that the architect could have provided his drawing and his layout and everything, and the QS would have provided the cost and the material and so on. So in terms of the project itself, that residence that the client is asking about, maybe the buck stops with the contractor person who is actually overseeing the construction of the building itself. I don't know.
Yes, I think there's a little bit of confusion here because really it's the contractor, as you say, who is responsible to deliver what he has contracted to deliver. But he's being advised, he's being watched by the QS to make sure that the costs remain in line with the budget. And the architect, on the other hand, is making sure that the building is built in according to the specifications which he has dictated. So basically speaking, it's your contractor who is your first call.
Because he has hands-on. He's the one who has his workmen and so on doing the project. So
right.
And that is why it's important for the timelines that you give to be very realistic. And usually those are team efforts and you benchmark it against other projects. It makes no sense that another project that is fairly managed in an efficient way, that project came in at say 18 months and then you give a timeline of 12 months. You have certain challenges on the side, for example, difficult soil condition or a difficult area in which to work and so forth, and you give an unrealistic timeline. You're really setting yourself up for delays. And it's not only on the part of the design team. Sometimes the contractors themselves should say early, is this timeline consistent with what your company, based on your resources, your past experience, is it something that you could uphold? You may find, a certain sector of our construction industry here who can take up a 10-story building in 6 months. It makes no sense that we have that as a timeline and another contractor who knows that based on his own experience that he cannot take that building up in 6 months, but they accept it because I need to get my foot in that door. They are setting up themselves for failure, and no amount of managing by the architect or warning by the QS will prevent that failure. So we shouldn't just leave it up to the contractor though. We need to evaluate the contract. And this is where another thing that quantity surveyors get involved in is a pre-qualification documentation where relevant to a particular project, even before you even put a bidder on a list, that you determine whether or not he is capable based on past experience, based on his resources, based on his current workload, etc. Can he manage this project and deliver it within the time that the client requires?
If I can add, I think what the person is asking more so is dealing with the structure of the project team. On one side is the professional team, and on the other side is the contractor. At that time, whoever is selected to manage the process, then that person will be responsible for the management of the construction project. If you select the contract administrator to be an architect, then the final say will be the architect. But each individual members of the team have their specific requirements that should be followed. Quant surveyors are masters of pricing and controlling cost. Engineer, depending on the engineer, they are more for structure and functionality. And architect may be there for specification and aesthetics, whatever it is. So each individual can be held responsible for their role. The contractor is a master in construction, so everything that is related to the construction matter, the administrator of the project would ensure that the value that the client receives is what the client had initially budgeted for, and actually all the requirements are met. So who is responsible per professional body? Whenever, if you're talking about costing, it will be the quantity surveyor. Then you have the engineer, then you have the architect. But in terms of who is finally responsible, who have the final responsibility, that will go to the person who is assigned the contract administrator. And that contract administrator should ensure that what the client receives is exactly what the client and the project team had discussed earlier from the inception of what the end result of the project should be.
Yeah. Thank you very much indeed. I think we have now exhausted that and we've run out of time. Before I close, there are 2 questions that I will leave to Dayton when he is doing his final wrap-up. A, will the presentation be available in soft copy? I think it's going to be on the website of the Jamaica Developers Association. And secondly, will there be any acknowledgement of participation from the Jamaica Developers Association? I can't answer that one. I will leave it to Dayton when he's wrapping up. But thank you all very much, ladies and gentlemen. Please join me in thanking Mr. Ryan Edwards, as well as panelists Winston Josephs and Veronica Royal for the very enlightening and informative and educational. I'm sure I speak on behalf of all of us when I tell them how much we have enjoyed their presentations and the lively discussion. Indeed, this brings the webinar and the papers and the Q&As to an end. Not to steal the thunder of my good friend Dayton Wood, I end this presentation without adding my quota of thanks to all the presenters, as well as the panelists for taking time out of their extremely busy schedules to educate us on the various points and counterpoints involved in exploring contracts, joint ventures, and the quantity surveyor's role in real estate development. To my mind, it has certainly been my pleasure to have acted as moderator for the webinar, and I have learned so much from each and every one of you. Thank you very much. And thanks for sticking with us, the audience. And I wish you all a very good afternoon as I turn you over to Mr. Dayton Wood, Chairman, the Jamaica Development Association Limited.
Thank you very, very much, Afif, and thank you for taking time from your day to be with us and to offer your expertise. Indeed, we couldn't have done this without you. From my point of view, as a layperson, I certainly learned a lot today, and from all the presenters. Certainly would like to thank Afif again for looking after tomorrow's children today, making sure that we have the legislation in place that we full understanding, so developers who are building not for today but for tomorrow, that we have good quality products on the market going forward. But thanks ever so much to Kevin Richards, who came in and pointed out the need for legislation for real estate investment trusts, which of course aligned very well with Lishan's point that there is no legislation covering joint ventures. So I suspect that those two could be twinned and certainly put into one piece of legislation. Stephanie, boy, you told us all about the contract, and you know, that's where it all starts, the contract. Because at the end of the day, when something is built, payments are made based on that contract, and difficulties are resolved based on that contract. So it behooves all of us to ensure that we get proper legal advice at every step of the way, and that it is fair and equitable to all parties. Ryan came to us today with letting us know all about the quantity surveyor's role, and indeed, I didn't know that he had so many hats to wear, the quantity surveyor. But it's important getting there from early so that the full scope of the development is known, quantified, and decisions can be made to go in this direction or that. Solves a lot of problems later down the road. To our panelists, Veronica and Mr. Josephs from VM, thank you ever so much. Alton, Morgan, Norman, JDA members, and Noel Levy, who joined us first time on. Hope to see him back again later on at another time. And of course, Carolyn Chuck for not being able to be on, but being with us in spirit and listening in. Thank you ever so much. And I cannot end without thanking our sponsors, without whom none of this would be possible. I speak of JN Bank, Jamaica Public Service, Gion, Wicon, Matalon Homes, DigiView Security System, Millennium Properties, Jamaica Money Market Brokers, Seaton Capital Group, Jamaica Property Company, Cement Company, and to you, our listeners and people who have signed up for this webinar, thank you ever so much. As usual, a lot of the proceeds will go towards students at the University of Technology in the building environment, building department. And in answer to Joseph Hehold's question, if you need to get a certificate for participation, you apply to the Developers Association. We'll be happy to provide you with one. There's a small processing fee, I think, of $1,500. And the presentations will be available on our website in soft copy for you to take down. Again, I thank you all ever so much for being here. And God bless you all, and to all, a good evening. Stay safe. Thank you.